Where people.
Share the happy moments with the Lord.
Thank you.
Lord, with the Lordship's indulgence, I would like to mention item 6. Appearing for the respondent number 6. Lord. The affidavit which is ready, I have sent to my client for execution. It hasn't come yet. Can it come in the next week, my Lord? I could not locate my learned friend of the petitioner. I could not inform.
Okay. By when will you file it?
Lord, I'm expecting within 2-3 days.
We'll have it after 2 weeks. That means it'll go after vacations. But I'll pass the order when the matter is there. I'll note.
I'm applied.
Yes, Mr. Burwa. How can I? Senior bench. Yes. 60.
1616, my Lord.
16.
Has been made. All the payment has.
Payment has been made. Okay. Mr. D.K. Jain, learned counsel for the petitioner, submits that during the pendency of the proceeding, the contractual dues of the petitioner has been released to him. Full stop. Accordingly, he submits that the present writ petition has been rendered infructuous. Full stop. Prayer is not objected to by the learned counsel for the respondents. Accordingly, the writ petition stands closed as having become infructuous, on having become infructuous. Yes, madam. You want to file an affidavit? Reply.
What has happened is that there is
Huh?
some disagreement amongst the petitioners. They want to pursue the case or not.
Otherwise, we will close it. What is there? You make a statement, we will close it. It's that brickling matter. They have also said that that's a gray area, whether the 2013 or 3 rules have been notified or not. They make a statement that it's not notified. Respondent number 9, in all probability, does not have a...
They're not running it.
They're not running it, so that we will close it. The other one, there is some materials available.
They have not mentioned anything. They're only...
In the affidavit also, they have not disclosed that they have a NOC, a CTO or CTE from the... Be here, argue it, why keep it pending? We'll close it if you say so. Have your instructions. At 2, we'll have it.
If Lordship will take it after a week, we are ready to argue on that day.
That is item number?
7, Lordship. 7 and 8, Lordship.
7 and 8. And they have also taken a plea that in both the writ petitions, it's basically the same petitioners.
Probably, Lordship. We have been engaged in this matter.
Okay. Ms. N. Begum, learned counsel for the petitioner, submits that they have been engaged. She has been engaged in the matter recently and accordingly praised that she... Okay. Ms. N. Begum, learned counsel for the petitioner, submits that she is in need of certain further instructions from the petitioners and accordingly prays that the matter be taken up again on 16/9/2025. Prayer is not objected to by the learned counsel for the parties. Also, accordingly, registry to list this matter again on 15/9/2025 along with WPC number 6308/2021. 6308 listed along with WPC 5346/2021 on 16/9. Else I'll forget what I have written now. Yeah? We'll hear the petitioner today. We'll hear the petitioner. Let's see.
Please, Lordship, I beg to mention number 21. Pass over for the day.
Why? You are for the petitioner.
Consent form APDCL.
This is with regard to that electricity connection.
Yes.
There is already a Supreme Court decision on that. Dilip Kumar or Dilip Das, dead. Oh, how will the status quo in the criminal civil suit affect here? Got to argue that only.
For the day, pass over for that.
On the prayer, a prayer is made on behalf of Mr. S. Sharma, learned senior counsel, appearing for the petitioner for an adjournment in the matter on the ground of personal inconvenience. Prayer is not objected to by the learned counsel for the respondents. Accordingly, a registry to list this matter after a week on a date to be fixed by it.
I get to mention item number 4, my lord.
40. Why?
Matter infructuous, my lord.
Matter become?
Infructuous, sir.
Why?
Settlement period is already over, my lord.
Okay. Mr.
Y Ali, on behalf of A Ali.
Mr. Y. Ali, appearing counsel appearing on behalf of Mr. A. Ali, counsel for the petitioner on instructions, submits that the issue involved in the present proceeding has been rendered infructuous during the pendency of the same. So prayer is not objected. Accordingly, he prays that the matter be closed. Prayer is not objected to by the learned counsel for the respondents. Full stop. In view of the above submissions of the learned counsel for the petitioner, the petition stands closed on having become infructuous. Yes. Mr. S. Burwa, S.R. Burwa, learned government advocate, appears for the state respondent. Learned government advocate is present for the state respondents.
Published.
May I please, your lordship? Lordship, I beg to mention item number 18 of today's list, lordship. If I am appearing on behalf of the petitioner, lordship. Engaged counsel, Mr. L.K. Bora has been suffering from viral fever and has appeared before this honorable.
Will not pass any adverse order. You already have a decree from the civil court in your favor. Oh, but still the mutation is refused. We'll have an instruction why it is done. And if it is found that they are doing it, we will allow your writ petition in your name. Let it be here. Be here when the matter. I'll not pass any adverse order. Don't worry.
Highly obliged, lord.
Just remind me if I pass any order. Adverse.
Please, Lord. I am making a mention on regards to item number 6, my lord. 6, my lord, the respondent number 2, they have filed one affidavit in opposition, my lord. Regarding that taxation matter, action they filed the affidavit 9/8, my lord.
Whether against a company or against
Yes,
the
yes,
director
yes,
also.
yes.
What is the stand in the affidavit?
We have received the copy today morning only. That
Mr.
Sir A.N. Sharma on behalf of Mr. S. Chamaria, my lord.
Mr. A.N. Sharma, learned counsel for the petitioner, submits that an affidavit in the matter has been filed by the finance department, and a copy was served on him today. So accordingly, he prays that he be granted 2 weeks' time to file a rejoinder thereto. So prayer accepted. A registry to list this matter after 2 weeks on a date to be fixed by it. File the affidavit in the
Yes, yes,
meantime.
I'm deeply obliged.
Lordship,
Yes, ma'am.
fine.
39. Are you there in the case? Let the matter be called up. We will do it in there. If there is any counsel who is there, ask him to come. You be there with him. Or he'll sit with you. You make the submissions.
Item 3.
Wait, please.
Hmm.
A for impeachment of the opposite parties as respondent number 4 and 5 in the connected writ.
But Mr. T. Chakraborty, learned counsel for the petitioner, and Mr.
P.
P. Hazurika, learned counsel appearing for the
Yes,
Huh?
Nine.
PTC. You have not been made. Wait. Also heard Mr. A. Bhattsaji, learned counsel for appearing for the standing counsel revenue department appearing for the respondent number 1, and Ms. U. Das, additional senior government advocate, Mr. N. Goswami, government advocate appearing for the respondent number 2, opposite party number 2 and 3. Respondents number 2 and 3 in the connected writ petition. Also, the present interlocutory application has been instituted by the applicant / writ petitioner praying for impleading the Bodoland Territorial Council authorities as respondents in the connected writ petition. Also, on perusal of the contentions raised in the present writ petition, as well as on perusing the order dated 1/8/2025 passed by this court in the connected writ petition being WPC number 4538/2020, this court is of the considered view that the parties sought to be impleaded in the connected writ petition are necessary and proper party for a due adjudication of the issues arising therein. Also, in view of the above position, the present interlocutory application stands allowed, permitting the petitioners, permitting the applicants of writ petitioners to implead A and B, Page 2, A to A, as respondents number
4 and 5.
4 and 5 in the connected writ petition, that is WPC number 4538/2020. Also, writ petition outlaw WPC 4538/2020. In view of the order passed today in IAS bracketed C number 2587/2025, impleading ACO A to A as respondents number 4 and 5 in the present writ petition, petitioner to file an amended cause title within 2 working days from today. Also, Mr. P. Hazarika, learned. Also, okay. P. Hazarika, learned counsel appearing on behalf of Mr. S.R. Rabha, learned standing counsel, BTC, accepts a notice on behalf of the respondents number 4, newly impleaded respondent number 4 and 5. Also,
I'll furnish the copy of the receipt.
accordingly, no formal notice is required to be issued. Learned counsel for the petitioner shall furnish requisite copies, extra copies of the writ petition upon the learned counsel appearing for the respondents number 4 and 5. So, registry to list those matters again after 2 weeks for admissions, reflecting the name of the standing counsel BTC in for the respondents number 4 and 5 in the cause list. Heard Miss W. You're not there in the case.
I am.
So and so learned counsel for the applicant. Also heard Miss R. Devi, learned counsel appearing for the learned CGC appearing for the railway respondents. And Mr. Goswami, you are also there. And Mr. N. Goswami, learned advocate, government advocate, appearing for the respondents number 4 and 7 in the connected writ petition. About opposite party number 4 and 7. Debbie, MDB for respondent number 1. CGC, opposite party number 1. Or opposite party number 4 and 7. 4 and 7. N. Debbie, Debbie will R. Debbie likhi for learned CGC appearing for opposite party number 1 and 8, and Mr. N. Goswami, learned government advocate appearing for opposite party number 4 and 7. Also, the present interlocutory application has been instituted by the applicants of the writ petitioner to implead the opposite parties number 9, 10, and 11, who had constituted a joint venture for execution of the work of Yatayase A to A. Page 7, A to A. Also, during the execution of the said work, the husband of the petitioner had met his death on account of electrocution, and the issue raised in the connected writ petition is pertaining to a claim for compensation on account of the death of the husband under the said circumstances. Also, in view of the above position, this court is of the considered view that the opposite parties number 9, 10, and 11 in the present interlocutory application are necessary and proper parties in the connected writ petition, and their presence would be required for a due and proper adjudication of the issues arising therein. Also, accordingly, the petitioner is permitted to implead the opposite parties number 9, 10, and 11 as party respondents in the connected writ petition. With the above observations and directions, the present interlocutory application stands disposed of. 6675/2021. In view of the order passed today in IA bracketed C number 2828/2025, the following parties are impleaded. Following parties, page page 6, number nidibade, Roman 1, Roman 2, Roman 3 koidiba. Page 6 and 7 are impleaded as respondents number
10, 11.
9, 10, and 11 in the present proceedings. Full stop. Petitioner to file an amended cost title within incorporating the names of the respondent number 9, 10, and 11 in the present proceedings. Full stop. Upon filing of the amended cost title, petitioner to take steps for service of notice upon the respondents number 9, 10, and 11 by way of registered post with AD. Also, registering to list this matter again after 4 weeks on a date to be fixed by it. Eto with the above observations and directions, interlocutory application stand लिखी ना?
Okay.
File an additional affidavit, Your Lordship.
Yes, yes, Mr. Goswami.
Sir, instructions, Lordship.
Hmm.
Some petitioners have. Some petitioners.
Mr. Ahmed, permit Mr. Ahmed to sit. Yes, what is your stand?
We have got instructions that whatever they stated in the affidavit now. Correct.
Not correct. File a reply to that.
Your reply.
Mr. Goswami, what is your stand? Oh, there is a list given that there is also a marking remark that these certain persons have not received anything. What is your stand on that? Some of them have received, but what about the others? You also file an affidavit to that effect. Mr. MZ Ahmed Lanit, Senior Counsel, appearing for the Power Grid Corporation. Heard Mr. Enagli, I heard Mr. S. Thakur, Learned Counsel for the petitioners, and Mr. MZ Ahmed, Learned Senior Counsel, assisted by Mr. AM Doctor, Learned Counsel for the respondents number 1 to 4. Also heard Mr. N. Goswami, Learned Government Advocate, appearing for the respondents number Mazur Likha A. Bhattacharjee for Standing Counsel, Revenue Department for respondent number 5, and Mr. N. Goswami, Government Advocate, appearing for the respondent number 6, 7, 8, 9, and 10. Mr. Bhattacharjee, Learned Counsel for the petitioner, has submitted that an additional affidavit has been filed in the matter, wherein the particulars, wherein the amounts received by the petitioners as compensation has been set out. Mr. Bhattacharjee further submits that that some of the petitioners are yet to receive constructions, and their particulars have also been set out in the said additional affidavit. Mr. MZ Ahmed Lalit, Senior Counsel, appearing for the Power Grid Corporation, disputes the position as brought on record by the petitioners in the additional affidavit and submits that an affidavit on behalf of the respondents represented by him would be filed within a period of 2 weeks from today. Mr. N. Goswami, Learned Government Advocate, has submitted that the instructions in the matter has been received by him. However, he would also place the same on record by way of an affidavit. So, in view of the above position, respondents are granted liberty to file their respective affidavits in the matter, countering the position emanating from the additional affidavit filed by the petitioners. Full stop. Accordingly, registry to list this matter again after 3 weeks on a date to be fixed by.
It will be 3 weeks.
3 weeks.
Probably.
Yes.
My lord.
Hmm.
My lord, the last order, my lord, instruction was called for, my lord. Petition, my lord.
You have received?
Oh, no, sorry.
Ask him to come. From 22, you are not in a position to bring the instructions on record, Mr. Goswami.
One chance, Lordship. The first time in this case, Lordship.
We don't know you. We only know your office. Your
One-
office is continuously appearing.
1 week time.
Mr. Bhuya,
Hello.
this is a market.
That is correct.
Is there an allotment made with you?
Lord, focus notice, my lord.
Sir, forget the show cause. That is subsequent. Where is your allotment? I might have missed out. So I'm asking you.
No, my lord, I have not annexed any such order.
So if there is no allotment, what is your right to that? And it's a
Possession-
government land.
Possession, my lord, is there.
Fine.
My lord, it was.
It's a government land.
Well, that is correct.
That land is being converted into a market.
Correct, my lord.
Now, how can you have a right over a particular plot of land in the market when the market is of the panchayat or the board, whatever it is? And they are regularly appointing a lessee. So whoever wants to do business there, they will come, sit, do business and go. It's a weekly market. Weekly hut
But
or a daily market.
daily market.
Daily market. So daily you will come, sit there, go.
It is a, my lord, not a market. It is a, my lordship has seen in some village areas, there is a bazaar.
But no, it's a defined market because there is a settlement being made now.
My lord.
Annual
No,
settlement is
my lord, my respectful submission, my lord, before my, whatever they want to do, they can do, but they cannot interfere with our livelihood, my lord.
no, they are
If-
not. They are only asking you to remove your permanent construction or a
Fine,
construction
fine.
there. To that extent only.
But,
And rightly so, it is not being done by the panchayat, it's being done by the
yes,
revenue authorities.
my lord, my lord.
Because it's land in question.
No, my lord, admittedly, my lord, what my submission, my respectful submission before my lord is that in a government land, my lord, we cannot occupy it forcefully, my lord. That is, any.
I'm not on that.
Right.
Your livelihood to the permission to do
Fine.
business there, nobody can object. Nobody can prevent you. But you can't make a construction there, which is
No,
the
we-
allegation.
We have,
You have said that you have a Sali Ghor there.
that is, my lord,
The permanent sort of, it's a temporary structure, but it's permanently there.
days, these saligors can be removed in a very, in a,
They don't want to do it. They don't want to do it in accordance with law. That is why they notice.
but we have responded to all.
You have not responded
So
to the notice.
So cause is there, my lord.
Annexure 4.
My lord.
Okay, let's see your Shuka's reply.
So cause is there, my lord, annexure 1 with reference to you are hereby directed to inform. My lord, may I read the annexure 1, my lord, page 16?
Hmm.
Then it will clarify with reference to the subject cited above. You are hereby directed to inform the reason regarding construction of permanent shop without informing to the undersigned. You report this should reach to this office within a so and so issuing this letter based on your report. Further action will be taken. This is a letter, my lord, issued to the Hasmat Ali Lessee, Miluzuli Bazar Market, so and so. Now, my lord, after the so cause notice, my lord, so regarding the providing placement for the shopkeeper mentioned, you have to give suitable placement for the shopkeeper enclosed here and submit report to the undersigned within 7 days from the date of issuing this letter, my lord. This is the annexure to my lord letter says that. Now, my
Who
lord,
is this Hasmat Ali? It's a petitioner.
my lord, no, he is the lessee. He is the
Lessee,
my
oh.
lord, who is now holding at that relevant period of
Ah.
time, my lord.
He has made a reply also.
My lord. Well, now my lord can find at reply is at page 18, annexure 3.
We'll
my
go
lord.
to 19 straight.
Yes, my lord. In Assamese, my lord, সন্মানপূৰ্বক বিনীত নিবেদন এই যে মই মিলিজুলি বজাৰৰ লেচি এই হিচাপে যোৱা 5/5/2022 ইংৰাজী তাৰিখত মিলিজুলি বজাৰত স্থায়ী দোকানঘৰ নিৰ্মাণ সন্দৰ্ভত মোক যি কৈফিয়ত তলব কৰা হৈছে সেই পৰিপ্ৰেক্ষিতত মই আপোনাক জনাও যে মই পৰিয়ালৰ পোহপাল দিয়াৰ তাৰণাত বিভিন্ন ঠাই কামত ব্যস্ত থকাৰ সুযোগ লৈ মুষ্টিমীয় কেইজনমান ব্যক্তিয়ে মোক নজনোৱাকৈ উক্ত দোকানখিনি বিলাকক পত্তন দিছে দুই এটা দোকানৰ ক্ষেত্ৰত এতিয়া মই তেতিয়া মই বাধা আৰোপ কৰা সত্ত্বেও তেওঁলোকে বাধা নামানি নিৰ্মাণ কাৰ্য চলাই আছে বৰ্তমান মই বুজিব পাৰিছো যে তেওঁলোকে মোক লেচি হিচাপে মুঠেই গুৰুত্ব নিদিয়ে গতিকে মহোদয়ৰ ওচৰত মোৰ কৰজোৰে মিনতি এই যে মহোদয়ে যেন দয়া কৰি ইয়াৰ এটা সুব্যৱস্থা কৰি মোক এই অবৈধ কামৰ পৰা ৰেহাই দিয়ে এয়ে মোৰ সৰল মিনতি।
So now
My lord. Now
he
this
was asked that why have you made constructions there?
instruction. He
Because
has
it is
said-
under his possession, basically, the
basically
market.
He is the lessee, my lord.
Lessee.
He is to look
Now
after.
your answer, your notice is at page 20.
Page 20 by the my lord,
Circle officer, naturally, the circle officer has to come.
Revenue land, my lord.
And you have not even responded to this.
But this, that my lord, instruction, my lord, I was asked for from the petitioner, my lord. They have said that some response was there.
In
No, my lord,
22,
but my lord, it is not been annexed in the petition also.
fine, where is your statement to that?
No, my lord, that statement is. I
So
have
we'll
observed it,
we'll hold it that there is nothing.
My lord, no, that,
So if there is a permanent structure made therein
my lord.
or a temporary structure erected,
No, my lord,
we'll ask them to be, that to be demolished, but at the same time,
my lord.
not to prevent you from setting up shops there, if
Setting-
permissible under law.
Setting up shops in the temporary nature, my lord. But my instruction is that these are very temporary in nature. What they have done, my lord, they galvanized seats, the walls.
But the
My lord.
question, you have also answered to that, you have not made that statement,
My lord, my lord.
that you have been singled out, whereas there are other people who have blocked the drain or the road. You
My
say you are 7 feet away from the road.
My lord, these are, my
Okay.
lord, very marginalized section of persons, my lord.
That is why I'm not doing anything today.
My lord, my lord.
I heard Mr. A.R. Bhuya, learned counsel for the petitioner, and Mr. N. Goswami, learned counsel appearing for the state respondents. Mr. Goswami submits that a last chance be given to him to place, to complete his instructions in the matter. Full stop. Prayer accepted. A registry to list this matter again on 17/9/2025. So, on the next date of listing, Mr. Goswami shall complete his instructions and apprise this court of the stand of the respondents represented by him. In the event the instructions are not forthcoming on the next date of listing, the circle officer, Baghbar Revenue Circle, shall remain present before this court along with the contemporaneous records to assist this court in disposal of the present petition. Interim order passed earlier to continue till the next date of listing.
Obliged.
You are Mr. A.K. Ghosh, appearing for the respondent number 5. Appearing for the respondent. Mr. A.K. Ghosh, learned counsel for the respondent number 5 is present. Let us see what it is.
Obliged, my lord. Highly obliged.
Yes, Mr. Vishwas, what is the position now?
My lord, there was an interim order, my lord,
Hmm.
staying the work. However, my lord, that has.
But that has been modified.
That has been modified.
Now it is only 10%.
Now it is only 10, that 10% comes.
And they have filed an affidavit also.
They have filed an affidavit.
You are not filing a reply.
No, my lord, because their affidavit does not in any case, my lord, affects my case. My lord, there is a.
What is this AAL?
AAL?
They have used that word. AAL was issued to the petitioner firm.
LOS. It's a-
LOI it should be. LOA, letter of acceptance, but it's written as AAL, so I was a bit confused. What is it? New word I saw.
acronym.
Mr. M. Biswas, learned counsel for the respondents, for the petitioners, has submitted that the petitioner would not be filing any rejoinder to the affidavit in opposition filed by the respondents in the matter. Accordingly, he prays that the matter be taken up for final consideration. However, a prayer is made on behalf of Mr. S.K. Medi, learned CGC, appearing for the respondents for an adjournment in the matter on the ground of personal inconvenience. Also, in view of the above position, a registry to list this matter again after 3 weeks on a date to be fixed by it. Also, an endeavor would be made to dispose of the matter on the next date of this.
Fixed date, my lord. Because, my lord, your lordship will appreciate this matter was hard. It was CAB. It was.
Everything will be done. Oh, no. Hey.
The last
No,
occasion.
kata. I forgot, sorry. It is stated in the by the learned counsel for the parties that the matter was heard at considerable length by a coordinate bench of this court on 1/8/2025, and the matter was fixed on 19/8/2025 for
2 p.m.
final disposal at 2 p.m. So, in view of the above position, the registry to verify the matter and list the matter before the coordinate bench, which had already heard the matter on 1/8/2025. I'm sorry.
I'm deeply obliged.
Yes, what about the alignment? Anything?
But we have made the joint verification lodge.
Hmm.
Building will not be affected lodge.
Not be affected.
Lodge.
Give me. What more, Mr. Bhattakur will want? It's a mosque or a madrasa? Madrasa. But your wall will go.
Wall is.
Have you seen it?
No.
Huh?
No.
Just go through it once. We'll take it up after some time. Give him a copy. You have a copy? Or you can give him this. Mr. Bhattakur, just go through it. If it is so, we'll close it. Yes, have you refunded the amount?
Not pursuant to the order dated 35/25, we are directed to file a counter affidavit. But
Forget your counter affidavit. What have you taken steps? Has your board met?
after some time, my lord. Senior is on legs. This is
Who is your senior?
SK Talukdar.
Okay, get it. Nobody for the bank. Who is appearing for the bank? You are appearing for the bank, ma'am. What is your what is your instructions? Who is he? She is in a position to talk. She can talk over phone. You just have an instruction whether this money, you have received the money. What happened, whether the board has taken any decision, madam? Just take an instruction whether the board has taken any decision, why, and if not, why. The board has not taken a decision because the new board came in much before. After that, why that decision? 55 lakh rupees of a citizen is just lying there. So kindly have that instruction and let me know. Okay? And rest assured, I only want the instruction. If it goes against you also, I'll not pass an interim order. But I want the instruction why the decision was not taken. After some time, yes. We are permitting you to shift. We'll give them 15 days time to shift to the new place. That was the only grievance you had.
Thing is that in the allotment order to me, they
That place has now been identified.
identified.
You'll go there. If you don't like it, can't help it. But they have given you, go there.
It is the condition precedent of the allotment order.
That condition was not fulfilled. That is why we had interfered in your favor. But now they have said that Golaghat Thana aru veterinary hospital Hongjogi Pothor Kakhor Homo Zukhor Sthan Apunak Byabohai Koribo Babe Dia Hol. Finished. What is more left? Disposed of. Hey, madam, naam to likhi lo bas. Ase na MDAS. Okay. No. Petri bhaiya.
Obligement.
You will not get the order before Wednesday. Because today I will not be able to dictate. Tomorrow I'll dictate, you get the order. So likhi lo na. 15 days time, Mr. Bhuya.
I will instruct from today or from the date of the order, my lord.
From the date of we'll give you a date.
My lord.
We'll give you a date. From that till that date, you make your arrangements, and from that date, you will have to shift. We'll provide
My
it.
lord. Obligement.
No, material. But Mr. S. Bhattakur, learned counsel for the petitioner, also heard Mr. B. Chaudhary, learned standing counsel, Public Works Department, respond number 1, appearing for the respond number 1, and Mr. N. Goswami, learned government advocate, appearing for the respond number 2 and 3. The grievance raised in the present proceeding by the petitioner pertains to the action on the part of the respondent authorities in changing the alignment of a road, which would have which was apprehended to have the effect of demolishing the structure of the petitioner standing over the plot of land in question. Also, this court also, there was no interim direction as such. Also, Mr. Bhattakur, learned counsel, Mr. N. Goswami, learned counsel for the learned government advocate, appearing for the respond number 2 and 3. Where is that instructions? Has today placed on record an instruction received by him from the District Commissioner Sri Bhumi, White communication dated 28/8/2025. Also, on perusal of the said communication dated 28/8/2025, it is revealed that a joint field verification was carried out in the matter by the Circle Officer, Bodarpur Revenue Circle, officials of the executive officials of the establishment of the executive engineer PWD, Sri Bhumi, North Territorial Subdivision Sri Bhumi, and on such joint field verification being carried out on 17/7/2025, it had come on record that the structure building of the petitioner standing over the plot of land in question need not be demolished, and only the demolishing of the boundary wall of the petitioner institution would be called for, inasmuch as the same was found to be falling within the right of way of the road under construction. Under construction. Also, it is to be noted that the said road is being constructed under the Assam Mala project. Also, the said communication further brings on record the fact that the building of the petitioner does not fall within the right of way oblique alignment, and the carrying out of the construction of the work would in no way affect the said building of the petitioner. Also, in view of the said position emanating in the matter, Mr. S. Bhattakur, learned counsel for the petitioner, submits that he would have no objection to the respondents demolishing the boundary wall of the petitioner's property, if the same is so requisite for the construction of the road under the Assam Mala project. However, he submits that the building of the petitioner now being contended to be not affected by the construction of the road and its realignment, the petitioner's grievance in the present proceedings stands redressed. Also, Mr. Bhattakur further submits that this is not government land, the wall is in your land. Submits that liberty be given to the petitioner to approach the respondent authorities for claiming compensation for the demolition of the wall, Ziraat compensation, as well as for land compensation in the event any portion of the land of the petitioner is so taken over is so required to be taken over for the construction of the road. Prayer is not objected to by Mr. N. Goswami, learned counsel for the petitioner, respondents. First off, in view of the above position, the building of the petitioner per se being now found to be not required to be demolished for construction of the road in question under the Assam Mala project, the basic grievance raised in the present petition by the petitioner stands redressed. Full stop. However, it is provided that in the event, liberty is granted to the petitioner to approach the concerned authorities claiming compensation for the demolition of the wall as well as taking over of any land of the petitioner for the construction of the road in question. Full stop. With the above observations and directions, the present writ petition stands disposed of. The communication dated 28/8/2025 furnished by Mr. N. Goswami is kept on record and marked as X for the purpose of identification.
Deeply obliged. Item 14, 15 and 19 are arising
Same.
of similar.
I think I passed an order.
Yes, my lord. On 29 lordship, it was not uploaded, but I
Oh, that order, no, not order, not. I think I dictated.
dictated lordship. The coordinate bench's order I have, my lord.
Ah,
That line lordship has.
I've disposed it.
Yes.
I think I gave you liberty to go to.
Appropriate forum, my lord, for damage and compensation.
I have also judgment. And identical matter.
I think this is the one we followed.
Lordship has had this matter on 29th. my lord.
I passed an order also.
WPC number 2916/23, my lord.
I had to leave that day, so I could not. 29?
16/23.
Similar order will pass.
Yes, ma'am.
Item number
14, 15 and 19, my lord.
14. You are Mr. A.S.
MA Chaudhary.
M.A. Chaudhary.
14, 15 and 19, my lord.
19. 14, 15, 19. Ekalage tholiba. A WPC number. A kabak disilo. Tumak dilu ne tak dilu sabason. 29 mood table te asa jan lage. 2916/2023. Similar order. Eta a single order pass koriba. A nam gita likil bosan sobra. Done. Dispose of.
Deeply obliged.
Yes, what is this? I don't understand. What is the relief you want?
Only paragraph 15 is remain, Lordship. Others already done. Eviction is, in fact, respondent number 4 is not authorized to carry the eviction. Well, there should be a notification empowering him. That is absent, lacking.
This is a writ court. I've seen your conduct. Should I be with you? Will not allow technicalities to come in. This is a public property.
Yes, Lord.
And public the money that will be earned is public money.
Public money.
So why should be with you? You have been given chance. You still have not made
Yes,
the
Lord.
payment.
But I am claiming the details bill that has not been.
Huh?
The details will only they have communicated me the total amount.
Mr.
Yes, I should, for my satisfaction, Lordship, like to inspect the details bills, Lordship. Here only send the total amount. This is the amount you have to pay.
You go and dispute it. You have not even disputed it. You are sleeping tight over the matter. Sitting tight over the matter. And you have already been evicted. What have you done with the property?
allotment is granted to another, my lord.
He is operating it.
Yes, my lord. As per my instruction, my lord, I received.
But so far as my paragraph 15, Lordship, that is, there is no notification empowering the respondent number 4 to carry out that eviction, Lordship.
Allotment was made by
Allotment, Lordship, earlier,
respondent number 4.
earlier it was by the
Where is this Act of 1990? You have a copy?
90. Yes, Lordship, this is 90. Section 31.
Where is that impugned order? NHIS.
Yes, His Lordship, this is the letter. When they are not ascertain whether
And what is this decision of this court here? You have and you were not operating. That's the allegation, that you were not operating for a long time. Then
publish a notification on 30th of January 2001 is 101, Lordship. All General Manager of District Industrial and Commerce Center of East District appointed as
Where is that?
page 101, Lordship. AIDC is not fall within that category, Lordship.
So if they have evicted you illegally,
And page 111, Lordship. XRX. S. Context, I would like to have advice from your kind and whether PM AICC Kamrup is authorized to act as state officer. They are not.
have you made the one that who has come in now, a party respondent? No.
Yes.
He's a party respondent. The person who has, after the auction notice, been now settled with that share.
He is not.
Then today, if we pass an order, it will affect him.
But sometime I will bring that.
You knew about it.
I will impede him.
No, you knew about it from 2023 itself, when the interim order was rejected. It is clearly recorded here.
No, at that point of time, it was not allotted to anyone.
No. Somewhere I found, wait. I found it somewhere.
At that point, my articles are there and they have issued an auction notice, Lordship.
Okay, are you ready to, we'll ask them to give you the complete breakup. We permit you to make payments within 15 days. Total amount with interest from that date. Then we will think.
Okay.
We'll break up naturally. They'll give it to you in 1 week. What is the amount now total? 61,70,152 as on December 2022. Till the plot was handed over to somebody else. Till that day, we'll ask them to calculate the
Let it be two, I will talk with.
rent along with interest at commercial rate. Are you ready?
Let it be at two, Lordship, I.
We'll see. You are interested with your money, but it will be 15 days only, full payment.
Let me take the instruction from my client.
Then you implead the other person. We'll hear and then we'll pass orders.
Advisement.
Yes, Mr. Goswami, what is this?
Possession of the landlord.
Huh?
They are not in the possession of the landlord.
How do you say that?
Instructions laws.
Where is your instructions? You're not in possession, Mr.
In possession, Lordship.
Who is in possession? There is no private respondent here. This judgment has not been executed. Why?
The petitioner has filed an application, the respondent number 3, Lordship.
I know whether this decree has been executed. Mr. N. Goswami, learned government advocate, submits that the instructions in the matter has been received by him. However, Mr.
K. Bora, on behalf of Mr. L. K. Bora.
Mr. T. K. Bora, learned counsel, appearing on behalf of the petitioner, submits that the arguing counsel, Mr. L. K. Bora, is not present in the court inasmuch as he is indisposed. So it is prayed that the matter be taken up on any other date. So, prayer accepted, a registry to list this matter after 3 weeks on a date to be fixed by it.
Highly obliged, Lordship.
None appears for the petitioner on call. Also, heard Mr. MS N. Bodoloy, learned standing counsel, Revenue Department, Revenue and Disaster Management Department. And Mr. Handick, you are appearing
Lordship.
for the government or for the revenue?
Lordship.
And Mr. J. Handick, a learned government advocate, appearing for the respondents number 3, 4, and 5. The issue raised in the present, the petitioner in the present petition has prayed for a direction upon the respondent authorities to authorize to her ex-gratia amount of rupees 2 lakhs in terms of the notification dated 15/11/2014 for on account of the death occasioning to her husband in a public place on being involved in a motor vehicle accident. A perusal of the materials brought on record reveals that the petitioners, the offending vehicle is duly identified and the registration number thereof is set out in the present petition. Also, in view of the said fact and it not being a case of hit and run, the petitioner is required to institute appropriate proceedings before the Jurisdictional Motor Claims Accidents Tribunal for compensation on account of compensation in relation to the death occasioning of her husband in pursuance to a vehicular accident. Full stop. In view of the above position, the petitioner would not be entitled In view of the above position, this court is of the considered view that the petitioner would not be entitled to being authorized ex-gratia under the provisions of the said notification dated 15/11 net 12 15/11/2024 2014 15/11/2014 full stop. Accordingly, this court full stop. However, in view of the fact that none has entered appearance for the petitioner today and also on the last date of listing, that is on 13/12/2024, this court refrains from deciding the case on merits and proceeds to dismiss the petition on for non-prosecution. A Gram Sabha had prepared a list. Thereafter, that list went up. Then your allegation is that the list was changed. Yes, who is there?
Priority beneficiary, but
Huh?
priority beneficiary, widow and physical hand.
Yes, Mr. Ghosh. No, it is you. It's who is the circle officer? Yes, who is there? The learned government advocate shall obtain and produce the list of beneficiary data prepared by the circle officer. That list is already here. That list is page 62 or 60, right?
60.
Yes, Mr. Hendik. Why the names of the petitioners who say that they were recommended by the Gram Sabha was replaced by some others? Any material?
That, Malatinda, that instruction, they say that no documents have been received against the petitioner number 1, 2, 3, and 4, whether they are widow or the physically handicapped.
Huh?
No information received regarding the holding the Gram Sabha of the office premises so and so.
So how was this list prepared? That RTI he has got page 60 onwards. This is by the circle officer.
Manipulation list.
Huh?
Onwards it is manipulation list.
That is it. Manipulation list or nothing. This is the list that was acted upon.
And page
Right?
35 is our list, Gram Panchayat list.
Got it. 60 is the list that was approved by the authorities for payment. Yes, Mr. Hendik. We'll have it at 2. You complete. Because if these people have been denied illegally, Ornodai is a big benefit they are getting. So we'll see why they'll be deprived. You will have to have good reasons. And where is that Ornodai scheme?
Guideline I have page 15.
50.
15.
15.
Next page, your lordship, page 16.
How is the list to be prepared?
By the Gram Panchayat, the beneficiary
Prepared by the Gram Panchayat lordships.
and
That list will not have to be forwarded to the concerned
District level monitoring committee.
lordships.
So why the matter was, the names were dropped in the,
Lordships by in my para.
This is neither here there. You get hold of your,
Lordship, my lord,
circle of-
give me some time. I have to, my lord,
No,
obtain the one of specific.
no, just call him up at 2, tell me. Just call him up and tell me. We'll see. Otherwise, these instructions will never come.
Lordship, my lord, that, no, my lord, that,
This circle officers, this parawise comment, circle officer is somebody. And this is the parawise comments he has sent. We have our doubts now. Call him, ask him whether their name were recommended by the Gram Sabha. If so, why it was excluded. Ask him to get the points. 4 or 5 petitioners only, 2 o'clock. Or we'll have him here. And if there is any genuine reason, Mr. Islam, we are not continuing with the writ petition, we are dismissing him. Because people have got.
On legs, my lord.
Hmm?
Dr. Saraf is on legs.
Oh, both are there. So Mia Bibi Raji, what should the Kaji do? We'll adjourn it. As prayed for, jointly prayed for, as jointly prayed for by the Learned Council for the parties for an adjournment in the matter on the ground that the arguing councils are presently arguing a matter in a different court. Also, prayer accepted, registry to list these matters again after 3 weeks on a date to be fixed by it. Any interim order? Interim order passed to continue till the next date of listing.
Obligator.
I have received the instruction.
We have
but
got,
some verification I have to take. Lordship, may kindly peruse.
why have you said that his registration is fake?
Lordship, number one, he is claiming ITC without there in being any supply of goods or receiving of goods. That has been found.
No, that registration is different. His
Lordship,
action of claiming ITC is different.
no, Lordship, because while taking registration, the address that has been shown, it was found to be not in existence in that place, the business.
There is no alternative address, place of business
No,
given.
Lordship. And subsequently, since the claim of ITC everything are done on portal and the returns are also submitted. So when there is no address, non-existence
Yes.
of that entity,
Yes.
Petition, Lordship.
I'm not on that. The word used is fake and ITC thing. There are 2 aspects. With fake, you have to give your place of business. If there is one, it's okay. Otherwise, then an additional list comes out where the other places are listed out. He says that you don't have an establishment at the declared place of at the declared address. If that be so, rightly done. Has this been, that excess credit that has been taken, has this been reversed?
Lordship, that part, Lordship,
Mr. B. Chaudhary, Learned Council for the Learned Council, Learned Planning Council, Finance and Taxation Department submits that the instructions in the matter has been received by him and an affidavit would be filed within a period of 3 weeks from today. Also, prayer accepted, registry to list these matters after 3 weeks. Full stop. In the meanwhile, the respondent shall invariably bring on record their stand by way of filing an affidavit in the matter. But I want a clarification on that fake thing. ITC we understand, but that fake thing we require. Bolo.
So far as service is concerned,
Hmm.
regard
Brief. So that acknowledgements are there. So done.
The other party is concerned, my lord.
What clarification? There are two owners of that part.
Yes, ma'am. There are other co-owners, my lord.
No, there are 4 or 2?
Four, my lord.
4.
Four, no,
2. That is the dispute.
Yes, my lord. But we are
He says 4. He
Okay.
says 2, you say 4.
four, my lord.
Who are the other 4? Other
Yes,
2?
my lord.
That's the only thing we got
Yes,
to
yes,
look.
yes, yes.
Where is that? Show me.
This
Then we'll
only
ask
copy,
Mr.
my lord.
Lal.
That's it, before purchasing that.
Page 95, my lord.
Wait.
Page 95. This is Assamese, my lord.
Huh.
Can you see my patta number 33?
Huh.
Tag number 203.
Hmm.
Our Montaibo, may I read, my lord?
Hmm.
Here, case number 15/2067, Gusor number
Border, sorry, no, 2007 ইংরেজি তারিখ
Sagaram to do, Sonit to do, Mithu to do, Is to do, Palhan to do, Elion to do,
Hmm.
so and so Name Soti, Potta 203 Nang or Pasbiga,
Dolosa.
Pasbiga Sarikota Sotolosa Zomi, Exona Potaba, Tetistam Potamiad. Here, my lord, 6 owners, my lord. Then, RKZ is high.
Just a minute. Oh, sorry, কথা মুঠ
Sokobika Mohoda 11/07 তাৰিখৰ
জমি একচনৰ
পথাৰ নামজাৰি হুকুম মতে
33 নম্বৰ ম্যাদী পট্টালৈ পৰিৱৰ্তন কৰি ৰেকৰ্ডৰ সংযোজন কৰা হ'ল। Okay.
then 5 and 6 minute then Sokobika Mohoda 11/9/07 তাৰিখৰ পথাৰ নাম
Where are you reading? 5 and 6?
thereafter subsequently minute as the RKZ Cycle Latmonal 5907 দুই Sokobika Mohoda 11/9/07 তাৰ পথাৰৰ নামজাৰি হুকুম মতে 5 and 6 নামৰ পট্টাৰ 33 নং ম্যাদী পট্টাৰ পট্টাৰ 2 নং দাগৰ অংশ
2003 নং ডাঙৰ অংশ
হৰিদা 1 বিঘা 1 কঠা 5 লেচা
1 কঠা 5 লছা 1 বিঘা 1 কঠা 5 লছা
শ্যামল হেমব্ৰন পিতা চান্দু হেমবন আৰু পত্নী দাগৰ 1 বিঘা 1 কঠা 5 লেচা দুই বৰ্ষা হাজদা পিতা কাদে হাজদা other co-owners, my lord, because the patta is the title deed, my lord.
Yes, Mr. Lal.
My right, basically the right of Harsa Harsa and Lord Samuel Hamram follows from the sale deed, Lord. So Lordship takes up.
No, in patta number 33, that is what is involved. Who are the pattadas in that patta?
Lordship, it's an Esmali land.
That's what I'm saying. So it's an Esmali land. You have given the lease deed of 2 different persons.
Who are the owner by way of a registered sale deed.
There are 2 persons who have given lease deed to you, executed a lease deed with you, with regard to a particular plot of land which they claim is theirs. Now, both these owners, along with 2 others, form an Esmali patta. Right? Is partition taken place? Right? Where is the no objection from the other 2 co-pattadas who have not given and executed a lease deed?
That is the question before this. That no objection.
That would be required. Because it's an Esmali patta. Partition not taken place. Tomorrow they make the investment, somebody raises an objection, they'll be in trouble. So show me the way out.
Lordship, first may kindly take a page.
Where is the policy to this effect?
Yes,
Page? Policy.
yes, but it's 102 minute.
Page
Here the next the complete by set of my lord rules, my lord. Page 106, my lord. Part of my lord, clause 4, 6, my lord. But the line has to be divided into 3 parts, my lord. Group 1, group 2, group 3, my lord. Group 1, my lord, kindly see. Applicant having suitable piece of land. Having suitable piece of land in the advertised location area, either by way ownership, long-term lease for a period of 19 years, 7 months, or as advertised by the OMC. Then group 2, it's a agreement for sale or and group there is no land matter. Then In bottom middle, the other condition with respect to offering of land as under. The land should be available with the applicant as of the date of.
Okay, Mr. Bodhakur. Sit down. Yes, Mr. Lal,
let's start
come
with
to
page
page
number
106,
106.
last A.
The land should be available with the applicant as on the date of the application and should have minimum lease of 19 years and 11 months at advertised by respective oil company from the date or after the date of advertisement, but not later than the date of application. Now, this is relevant. If the offered land is on long-term lease and there are multiple owners, the word used is owners, not patadar, then lease deed should be executed by all co-owners of the offered plot. In case lease deed is not executed by all co-owners, such lease deed shall be treated as invalid. Now, Lordship may kindly take up page number 62 for a moment, my lord. Lordship, this is the map, my lord. There is a longitude and latitude, my lord, has been provided at the bottom and my lord. Lordship can see, my lord. Demarcated plot, my lord. Now, Lordship may kindly for a moment take up the requirement, my lord. That is at page number 39, documents required for all categories, my lord. Start from page 38, email dated 29. Page 39 and 40 are the relevant documents applicable for all.
Okay, the total land
Lordship.
is more than this page 62. There will be another plot of land. Now, there is two further patadas there.
Lordship.
Now, where is the part?
That is the question, my lord.
Sir, Lal, you know it. I want to understand.
My
That's why, sorry,
my-
excuse me.
my apologies, my lord.
Okay, we'll have it then. We'll hear the matter. Now, today you want to sell that land. Whether no objection from the other two or the other three, one wants to sell, other three is to be taken, not required. Okay, where is the law? Just satisfy me with the law. Because this is an unpartitioned land, right? So you have a share there. But which exactly is the share? How has it been determined?
Satisfy you all, lord.
Then tell me that much only I
My lord,
require.
my only contention here, my lord. How a person becomes the owner of a plot of land, either by sale, inheritance, my lord, gift deed, it all comes within the meaning of sale, my lord. It is not inherited property. I have purchased it, my lord. I have purchased it after taking all the necessary permission from the circle office, my lord. And if your lordship sees the voucher again, my lord, the voucher that my learned friend was referring to, it says that how we will determine that you are the owner of a land is by way of registered deed. That your lordship may kindly see the.
No. That is not the intention, Mr. Lal.
Lordship.
We understand that you, the person who the lesser, has that much of property, 1 bigha something each, no dispute on that. But where is the partitioning of the property? Then just satisfy me on that. That much only, that's the only barrier that I'm having. You remove that, you take the order.
Next Tuesday,
No, today. That much only show me. I don't know. I want to know.
Lordship, I think, my lord, there are three things, my lord. As my expected submission, lordship, is that
they need not execute lease agreements with you, but they'll have to give a no objection. That okay, fine. This is because it's still an Esmali patta.
I become the owner of by way of a purchase, my lord.
That is what I'm saying. How is this? That whole thing is one patta. Where is that division of the patta? Why is it not required?
I take it up on next Tuesday, if your lordship. Because your lordship can see,
We'll have,
On my part to satisfy.
I don't understand that portion. Mr. Bhattagu will ask you if required.
No, madam. Passing on judgment.
Now you can sit and
Milord, may kindly take a page 10, Milord.
page.
Page 10. Oh, sorry, 110, Milord.
It was only on this point that the court had kept this matter for hearing, right?
No, the court has kept this hearing only on the point, Milord, that my learned friend argued that 2 lease deed was executed, Milord. Not on this point, Milord. Lordship, may kindly take a page 100.
But that is not what is revealed from the letter cancelling your.
No, that is the point, Milord, that Lordship has asked.
You have given up that. You only 2 lease deeds execution is your problem.
Yes, my lord. But the other
Oh, how does it harm you?
the other co-owner has done.
There are 2 co-owners. Oh, you are not with the 4. You are only with 2.
But they have to, my lord, the
Mr. Bhattakur?
no.
Yes, I remember.
No.
I remember. My Lord Justice Barua's order.
Yes, my lord. The
Ah,
first-
let's come to that.
Yes,
Paragraph 9 and 10,
the
Milord.
first day, my lord.
Number 5, paragraph 9, 10, Milord. Order dated 30/8/2024, Milord.
No, he has taken.
Yes, my lord. There is no misset bounds, my lord. Lease deed also, my lord. In a lease deed, my lord, he claimed he is the lessor is the absolute owner, my lord, and pattadar, my lord. That having the partition deed also, my lord. Case 54 of the lease deed, my lord.
But if that plot is demarcated and nobody is having any objection, why
No,
you are?
where is the demarcation, my lord? This circle officer report says is at 203 flat, my lord.
But circle officer says there is no other owners to that property.
But the Jawabandi says, my lord, there are other
Forget the
co-owners.
Jawabandi, the circle owners, circle
It
officer's
cannot
report
be-
is there.
It cannot be accepted, my lord.
How can you go beyond the
This is
revenue authority?
kindly see, it is a CC, my lord. It's a company, my lord. We have to invest all, my lord.
It's your investment.
Yes, my lord.
So you are also, the respond number 3 is also not operating now.
No, my lord, because there is an interim order, my lord. Because, my lord, in the online application, he claimed to be claimed as a self, my lord, in the column, my lord.
But that is permissible.
But he is only a leaseholder, my lord.
But he has the lease in terms of the 19 years lease.
Yes, that's true, ma'am. But my lord, in the lease deed also, my lord, can you see the lessor claim himself is a absolute owner. He is not an absolute owner, my lord, without having the partition deed, my lord. He claimed as a pattadar, my lord.
That is not your ground for
Yes,
rejection.
my lord. All the co-owners, but there are other co-owners, my lord. My lord, see, other co-owners in the, my lord.
Lordship takes up page 110, Milord.
Well, I'm one husband of court, my lord, in the beast to go.
Sir, if Lordship takes up 110, page no 110, Milord.
Para, my lord, 10, my lord, 10 onwards, my lord. Carried, my lord.
Just a moment. You give this decision to Mr. Lal.
Yes, my lord.
We'll take it up at 2.
Can it be on Thursday, Milord?
Today, try. I'm there. I'm trying to understand only. Let's see.
Kindly not today, Milord. Some person, Thursday, Milord, this Thursday, Milord.
Okay. Mr. A. Learned Counsel for the petitioner submits that he be granted a day's time to complete his to make his submissions in the matter. So, prayer is not objected to by the Learned Counsel for the respondents. Also, raised to list this matter again on 18/9/2025 as a fixed item.
18 minutes.
18. Just show me that
No,
that is something where I'm not being able
Only
to
question
appreciate.
that is,
Mr. Ali, if I can have your assistance.
Proper person, my lord.
What has happened here is that there is a patta 33 and it's an Esmali patta. The 4 persons are there. Now, the lease deed for a particular plot of land, there were 2 lease deeds, 1 lease deed, that is a different issue. 2 of those pattadas have offered their lands to the petitioner on lease for opening a retail outlet. Now, while they have done it, there is no partition by meets and bounds of the property as such. So they have raised an objection. The other 2 co-pattadas have not given their objection or executed a lease deed. Now, is that required when it's an Esmali patta? The others also should have, or what is the process?
It depends upon the position.
Ah,
Person who executed the lease deed, your lordship,
is in possession of the land.
apparently he will lease it out only in respect of his position because he is already a pattada. At least he has a share.
He has a share.
He has a share, and so far his share is concerned, he can lease it out. The other side, it takes the objection that there should be a partition. Partition matter or before the ADC or before the court below your lordship, that can be done, your lordship.
Here,
No problem.
here the objection is that you have given us and we will be investing money. Tomorrow some problem comes up. So they cancelled it. So in that view of the matter, can that be said to be an erroneous view of the company?
Pardon, your lordship.
Hence, if the company says that the other 2 co-pattadas have not given, having not given their objection, no objection, or they also not being party to the lease deed. So today we take that land and we invest, and tomorrow somebody objects, then we will be in trouble. Our money will go down the drain. So they cancel it. Can it be said in the fact situation of the land that it will be an erroneous decision?
It is their apprehension that in future they might face problem.
And is there a possibility of facing a problem in such a
The measure of precaution, because when there will be partition, your lordship, the person who has leased out, he may not have that share.
share? That is it. That's what was troubling me.
Because there is no choice.
understand, my lord.
That is what was troubling me.
The case when the Allahabad High Court observed.
So, Mr. Ali, today we permit them, but tomorrow somebody, because those 2 are neither before us nor before them, they make some claim that no, this land actually is my share. And then a partition will have to take place. And we don't know today for sure whether Mr. Lal would be given the same very plot of land or some other plot of land.
Oh, sir, may I put one question? Suppose I have purchased the land, sir. I was not the original patta. I purchased it from the other patta.
When he will purchase his share, it is subject to partition.
Partition.
Section 44 of the
So,
Transfer of Property.
I think nothing more is required. Next. Eto kiman disilu? Kiman 18/9. Nalage. I've got my answer. On
Thursday, lord.
on 9/9 for further hearing. Thank you, sir. Huh? 11.
Satisfy you all.
I can't help it. This was something which was troubling me. That's why I asked it.
On 11th, my lord. Oblige.
Yes.
My lord, they're awaiting
You
reply
finally
for a
woke
long
up
time.
after 1972
My lord,
in 2023.
we did not wake up, my lord. The authorities kept it pending.
They have lost the whole thing. Yes, Mr. Barbujay, what is it?
Have received the voluminous instructions and we file our affidavit, but
No, voluminous, it would be voluminous because the land is voluminous.
and this will seven
Compensation would also be voluminous.
here. Now, my lord, the area falls under BPC.
at that point of time?
At that point of time, it was not BTC, but now it is BTC. So
PTC has been made a party respondent
They
here.
have been made a party respondent.
now issue of 702 and odd big house. The writ petition, they are compensate them or my lord to return the land. But that circumstances now and falls within the
I'm sorry, this land was initially taken over by you. So what did you do with that land?
my lord, there's a series of
You will have to justify the thing that it comes within the Sealing Act. So you have rightly taken. If you have rightly taken, what is the liability? If there is a liability, you will have to pay him because it is of 72. That time BTC was not even contemplated about. Today, if we have to return the land, you will have to identify to the, you will have to issue necessary directions to the BTC that this land that we had taken up will have to be given back. Then BTC would come in. First, you will have to discharge your owners.
93, my lord, there is an adjudication. Said that 600 filling surplus, so it goes to the government and I get paid compensation as the rest 702 because was to be returned to us.
There is already an adjudication.
There's already an adjudication, but then without following that, in 2005, they issue another, my lord, draft statement under 7.2, which we objected that there is already an adjudication of 93. Now from 2005, my lord, now the ball is rolling between, my lord.
We will not permit that. We will not let
PTC and-
Mr. Borpujari go away that far, that easily. We'll have him, we'll determine, then the question is who will pay, how much. No, I don't want it. I'll read it. It's better for me to read it at my chamber. That means when you file an affidavit. But this time, we'll require your affidavit. No further adjournment. The people, if they get it, they get it. Otherwise,
Definitely.
and one of the petitioners, they are all senior citizens. Barring respondent petition number 6, others are all senior citizens. So we should not keep them waiting. When will you file it?
Sibyl kindly accommodate me for 2 weeks.
Mr. R. Borpujari, Learned Counsel for the Learned Standing Counsel. R. Borpujari, Learned Standing Counsel, Revenue Department submits that the instructions, complete instructions has been received by him in the matter and would file an affidavit on or before 17/9/2025. Also, Mr. B. Chaudhary shall also file the response on behalf of the respondents represented by him on or before 17/9/2025. Petitioner to file a rejoinder to the affidavits filed by the respondents, comma, if so advised, comma, on or before 15/10/2025. Registry to list this matter again on 24/10/2025.
Deeply applies.
I'm applying.
Please, Lordship. I'll file a affidavit in reply. Affidavit of 2 weeks time.
No issue. But what is that document you have to, other than the document at Annex A? Because there is this is your writ petition, Mr. Counsel.
Lordship,
Just to understand, for me to understand, you may have something. That's why I'm just trying to take you there. You come to the impugned order. Last line, page 15. Last line.
During the course of hearing,
You could not produce any document in his support. Right? Now, where is your statement that no, I had produced A, B, C, D in your writ petition, that was not considered by the registrar?
it mentioned hearing.
Then what is left? We only wanted an affidavit. He has written many things, but that affidavit was only on the point. You have brought on record a certificate at page 13 that this is your share purchase certificate, right? They have denied it.
That they didn't deny it, Lordship.
No, your earlier before the register was that you have got no documents. Now in the writ petition, you have brought a debit cash voucher and you have written there credit, right? The name of the society is Sony Housing Development and Finance Cooperative Society Limited. Sony Housing DNF, where and is not there itself. They say this is not our
Society, they have time to.
We'll
Maybe
fix this
right.
matter on 17th. You have your affidavit by 16th. Mr. G. Kakoti, Learned Counsel for the petitioner, submits that an affidavit in reply on behalf, a rejoinder to the affidavit filed by the respondent number 4, 5, and 6 would invariably be filed by him on behalf of the petitioner on or before 16/9/2025. Registered to list this matter again on 18/9/2025. No further time would be granted to the petitioner to file his rejoinder in the matter.
Unless.
Yes, Mr. Ali.
Lordship. this
Are we
matter-
taking up this matter for final disposal? Every pleadings are complete.
My lord, yes. Very short matter.
This is regarding dispute, your lordship, that is a title dispute, ownership, as well as the mutation, your lordship. So, this petitioner, your lordship, he purchased land measuring, your lordship, 1 bigger 2 quota 18 lessons in that number 982 public new 1396.
Petitioner
Same, your
purchased,
lordship,
petitioner purchased,
purchased land measuring 1 bigger 2 quota 18 lessons in that number 982 old and 1396 new. He got her name mutated
193 or 982 and
982 and it old 1396 new.
okay.
1396 new of pattern number 9155 old
1554.
old 653 new by a sale deed in the year 2013, your lordship.
Who is the vendor?
Vendor is, your lordship, Kanak Boisha. Now, your lordship, he got her name mutated also, your lordship, on mutation, your lordship got on 5/8/2013.
Before the circle officer?
Circle officer, your lordship, and her name has been corrected also, shown in the Jamamandi white remarks jaw.
Jaw.
Jaw, your lordship.
Hmm.
And then your lordship will find this 982 die, original die, your lordship, if it contains total land measuring 9 bigha 3 quota 14 lessons.
9 bigha?
3 quota 14 lessons.
Okay.
So in the same die, your lordship, my learned friend's client, that is respondent number 4 and 5, your lordship, 5 and 6, your lordship.
Respondent
Well,
5 and 6.
they also purchased, your lordship.
Under 982.
Lordship, that is the respondent number 3 and 4, your lordship. They also purchase land measuring 4 biga, 2 kota 4 lesa. 2 biga, 2 kota 4 lesa, your lordship, got mutation.
Same patta, same.
Same patta, same dag, your lordship. But there is saleable interest, so far total land is concerned, that is your lordship, it is 9 biga, 3 kota 40 lesa. It is not exhausted even after selling land to my client, your lordship, and to the client of my
patta.
learned friend. Respondent number 3 and 4.
When did they make this purchase? Sale did?
Lordship,
Sale did was of
lordship, my sale did is your lordship.
2013. Their sale did?
Their sale did, I do not know, your lordship.
Okay.
They have not.
Mutation done.
Anyway,
Mutation done.
prior to
Mutation
ours,
done. Mutation? 3 and 4 name mutated?
they got mutation. They have got mutation, they are possessing their land, your lordship. And we are possessing our land, your lordship. There is no dispute with regard to possession. No dispute with regard to possession, your lordship. They are
Possessing their respective share of.
They are possessing, your lordship, 4 biga 2 kota 4 lesa. We are possessing our 1 biga 2 kota 18 lesa. Adjacent plot, your lordship. Now they raise objection before the edit that our title is defective, our sale is illegal, this and that.
Who the purchaser?
Yes,
They
sir.
respond number 4 and 5.
Respondent number 3 and 4,
3
your
and-
lordship. Raise objection before the ADC, your lordship. Is not actually competent, because if anything is objected, your
Okay.
lordship.
What is the nature of the objection?
Objection is that our title is defective, it is illegal, your lordship, and our mutation, so far mutation is concerned, that is also illegal. So on the other hand, we also challenge their contention, your lordship,
How?
that their
Filed a reply.
their sale deed is not correct.
Oh,
Their ownership is, they don't have any ownership over their offer, and mutation is also
where did you make this challenge before the ADC himself?
such. So it seems, your lordship, thereby that the dispute is with respect to title and mutation of the land, your lordship, and ownership. So in that case, your lordship, there are a number of decisions of our High Court that it should go to the civil court. Civil court will decide regarding title, regarding ownership, regarding mutation is correct or not on the basis of title.
The possession otherwise is not disputed.
Possessing are not disputed, they are possessing their land,
So it
they
is
are
to follow.
possessing.
Hmm.
The learned ADC, your lordship, during the COVID period, your lordship, we file objection, no doubt, but without hearing us, your lordship, during the extreme COVID period, also pass the order. That is, in that order, your lordship will find at page, it is
What is the order, nature of the order?
13,
Before we go to
30.
that,
Annexure 13, your lordship will come to page 9.
we'll go, Ali. Mr. Ali will go. But what is the nature of that order?
Order, your lordship, my sale deed is not correct, your lordship, according to him. Title is defective, and so far mutation granted to me, that is also illegal. So he has decided as if he is a civil court. So that was challenged, your lordship, before the board. That was challenged before the said.
AVR.
So the honorable board, your lordship, confirmed the order passed by the learned ADC, your lordship, dated 22/12/2021, your lordship, and hold that actually whatever land I have purchased, it falls in DAG number 982, not in DAG number 1396.
This is a further additional conclusion arrived at by the
By
AVR.
the board, by the board. But so far cancellation is concerned, your lordship.
That was upheld.
That was upheld. That's why I am aggrieved. Before the learned board, your lordship, we argued on merit as well as that this matter being a dispute with regard to title, ownership, as well as the cancellation of mutation. So this revenue forum, the revenue court has no jurisdiction to try, decide it. So
Were the vendors of both the petitioner and respondent number 3 and 4 the same person?
different.
Different person. Yours, the ABR has said your land now falls under DAG number 1396.
1396 new. 982 old. They also purchased in DAG number 982.
To 1396. So what is the specification, what is the special thing about this conclusion? It's otherwise also 982. You have purchased your land in
With the
982.
original DAG, because from the original DAG, your lordship, this 1396 and other DAGs have
Were taken out.
carved out to your lordship. The number of DAGs, because original DAG contains 9 bigger 3 quarter.
So
Four
what is your further submission?
So my further submission, your lordship, that my so far mutation is concerned, that should be kept intact, because we have already filed at the civil suit, your lordship.
You have already instituted.
Already we have filed a suit, we have annexed it, your lordship. That is, annexure, your lordship will find at page 99, your lordship, annexure 14. We have already filed a title suit there, your lordship, and we have got an injunction also. In spite of that pendency of the title suit and the order passed, maintaining status quo, that is the injunction, your
Title suit is for?
lordship.
Title suit is for what?
For
What is the
declaration
belief?
of right title interest.
Hmm.
That is ownership right, your lordship, confirmation of possession, your lordship.
Hmm.
And on the basis of the title deed, as I have referred, your lordship. That is Eviction 2.
So it's just right title interest in the
Lordship,
property and
lordship.
possessory?
Lordship, I am coming.
Huh.
That is
Now we can go. This is the thing.
lordship 99. I'm just reading, your lordship.
Hmm. That is the plaint.
Lordship, I am reading just the prayers, your lordship.
Okay.
Prayer 1, it is therefore prayed that your honor may be pleased to pass a decree for declaration of right, title, and interest of the plaintiff over the suit land as described herein below. 2, declaration that the mutation of the name of the principal defendant over the entire land measuring 4 bigger 2 quarter 4 lessons is illegal. That is their mutation. Lordship, that is illegal, void, and liable to be cancelled and not binding upon the plaintiff. Confirmation of possession of the plaintiff over the suit land as described herein below. Permanent injunction, any other relief. So these are the reliefs claimed, your lordship, in the suit. Now your lordship will find the findings of the learned ADC. It is horrible findings, your lordship. And if this way the revenue authority, your lordship, decides matter.
We can continue at 2.
Yes.
It will be, we have a meeting. It may go on 5-10 minutes. So by 2:10, we will take up this matter. Mr. Ali, any inconvenience?
Lordship?
Any inconvenience?
No,
2:10?
no.
Understood. Yes, Mr. Ali. We have now got the things. Now you can take me to the orders.
Lordship,
We have got the outline. Now you can take me to the impugned orders.
now, your lordship, in this read, the petitioner has impugned 2 orders, your lordship. One, the ADC, your lordship, and the other one, your lordship, of the Board of Revenue, which has confirmed the
Order of the
order of the ADC, your lordship. So far, the order of the ADC, I am placing first, your lordship.
Yes.
Please. At page 87-98, your lordship. Annexure 13, your lordship. Page 87. Lordship will come at page 90, your lordship. Property portion, your lordship, the last para, your lordship, of the page 90. The order passed by the learned additional deputy commissioner, land records branch, office of the deputy commissioner, Kamrup M, for correction of land records on 27/5/2013 in favor of Sri Chandra Vaishya and Sri Kanak Vaishya, that is our vendor, your lordship, my vendor, was based on the report submitted by the circle officer, Azara Revenue Circle, but that point of discussion is that. Now your lordship will find here,
Both are vendors of the petitioner, Chandra Vaishya and Kanak Vaishya.
Kanak Vaishya, they are my vendor, your lordship. And your lordship, right, this order has been passed by ADC and he has taken up the order of the earlier ADC, your lordship. That earlier ADC has committed illegality and irregularity, your lordship. So under the section 151 of the regulation 151 of the lordship, some land and revenue regulation, he can't revise, your lordship. Law is dear. I'm just placing, your lordship, 151. Section 151, regulation 151. At page 109, your lordship. The board or a deputy commissioner or a settlement officer and a survey officer may call for the proceedings held by any officer subordinate to it or him and pass such orders thereon as it or he thinks fit. Note, an order once passed in any case cannot be revised either by the officer who passed it or by his successor in office, but this order does not apply to summary registration orders. Now your lordship has got the point, your lordship. ADC has actually revised the earlier ADC's order, your lordship. This. Now your lordship will come to the page 90, your lordship. The order passed by the learned additional deputy commissioner, land records branch, office of the deputy Kamrup M, for correction of records on 27/5/2013 in favor of Chandra Vaishya and Kanak Vaishya was based on the report submitted by the circle officer, Azara Revenue Circle. But the point of discussion is that entire area of land covered by Doc number 1396 of the below mentioned schedule, land was mutated in the name of the first party on 28/11/2011. And there was no excess land covered by Doc number 1396. In such a situation, the land records correction order in the same Doc number 1396 for an area of 1 bigha 2 kota 18 lassa, that is petitioner's land, in favor of Sri Chandra Vaishya and Sri Kanak Vaishya was not practicable. Moreover, the first party purchased the below mentioned scheduled land by executing registered sale deed at the office of the sub-registrar Kamrup M from the recorded landowners. The executed registered sale deed in respect of first party is legally valid document. That's been decided, is legally valid document and was neither cancelled nor modified by any court, competent court. Thus, the report submitted by the circle officer Azara Revenue Circle on the petition submitted by Sri Chandra Vaishya and Kanak Vaishya can be assumed to be submitted without proper verification of facts. He has decided as a civil court. The erroneous report which was submitted by the circle officer Azara Revenue Circle and based on which the order of correction of land records was passed on 27/5/13 in favor of Sri Chandra Vaishya and Kanak Vaishya. Immediately after correction of the land records as per said order by the circle officer Azara Revenue Circle, Sri Chandra Vaishya and Sri Kanak Vaishya sold out the land measuring 1 bigha 2 kota 18 lassas
to Srimati Harbindra Kaur, that is the petitioner, after obtaining NOC from the competent authority and executed registered sale deed now on 24/7/13. Thereafter, the name of the purchaser Srimati Harbindra Kaur was also mutated in the land records on 5/8/2013 by the circle officer Azara Revenue Circle. In practice, before issuance of NOC for sale purchased by any movable property, field verification report has been sought for from the concerned circle officer, and after examination of the circle officer, generally NOC is issued after due approval of the competent authority as governed by law. But in the instant case, how can circle officer Azara Revenue Circle submitted an affirmative report on issuance of NOC for sale versus land between Sri Chandra Vaishya, Sri Kanak Vaishya as seller and Srimati Harbindra Kaur as purchaser, based on which NOC was issued for transfer of ownership of the land.
Mr. Ali,
From the above,
Mr. Ali,
it is
this-
important, Your
no,
Lordship.
Okay,
Now, next para.
from the above.
From the above discussion, it is clear that the first party had purchased the below mentioned scheduled land from the recorded landowner by executing registered sale deed after observing due procedure, and their names were also mutated in the land records. The sale deed that was executed in favor of the first party was neither has been cancelled by any competent court nor has been challenged by anyone before any competent. As such, first party is the valid and legal owner. Valid and legal owner of the below mentioned scheduled land. The second party, especially Srimati Harbindra Kaur, that is the petitioner, Your Lordship, purchased the land measuring 1 bika 2 kota 18 lasses bearing tag number so and so of the below mentioned scheduled land from Chandra Vaishya and Kanak Vaishya, whose names were incorporated in the land records as per the order of correction of land records was issued on so and so, by ignoring the right title and legal ownership of the first party at that time. So this is the finding that he has decided, Your Lordship, that my sale deed is not correct, is not genuine. The sale deed which has been produced by the first party, that is the respondent 3 and 4 here. So it is correct. So there, so far purchase is concerned, it is legal. Everything is legal, Your Lordship.
Because
Yes,
there was, according to his finding, there was no further land in 1396.
Lordship. But as I have submitted already, Your Lordship, this 1396 is a new duct. Original is 982, which contains, Your Lordship, 9 bika 3 kota 4 lasses of. So there is still surplus land, Your Lordship, after having purchased by the petitioner as well as purchased by the respondent number 3 and 4. So that being the position, he has not discussed anything. And Your Lordship will find this order is dated 21/12/2021, Your Lordship. Extreme COVID period, Your Lordship. We file objection earlier. So far the hearing is concerned, we are not given the hearing, Your Lordship. In a hasty manner, Your Lordship, we passed the order, Your Lordship, behind our back, Your Lordship, and that too against us, Your Lordship. Now, this order was challenged. This order was challenged by the petitioner, Your Lordship, before the Board of Revenue.
113.
Now, Your Lordship will find this Board of Revenue, Your Lordship, what it decided, Your Lordship. Now, I am coming to paragraph. It is at page, Your Lordship, 112.
Starts. huh?
112, Your Lordship, it is Annexure 14. Your Lordship will come paragraph 4, 5, and 9. 4 is at page 115, Your Lordship.
Yes.
4, Your Lordship got it. Para 4. Page 115, Your Lordship. Primary disputes resolved around the ownership and mutation of the land. Ownership and mutation of the land. So ownership cannot be decided by revenue authority at under any circumstances, your lordship. Ownership and mutation of the land into different ducts, namely 982 and duct number 1396. That is the mistake committed by the Board of Revenue. 982 is the original duct.
Same.
1396, your lordship, it is the carved out duct, your lordship. Now he says that entire duct number 1396 belongs to him because it contains land measuring 4 bigha 3 kota, 4 bigha 2 kota, 4 lesser, your lordship. That being so, your lordship, that he has carved out, including my land also, your lordship. Now, as on today, there is no duct 982, your lordship. The Assam Board of Revenue has held that my purchase is right. It is legal.
980.
I have bought, it is in 982. If 982, then where is the 982? As on today, your lordship, in the official map as well as the record, there is no such duct 982, your lordship.
So
All duct
982 has now become 1396 and other ducts.
1396 and the another is 1393, your lordship. That is there, your lordship. We are not concerned with 1393. Anyway, your lordship, so far possession is concerned, your lordship, he is possessing his land, the petitioner is possessing her land, your lordship. So possession, there is no dispute.
So 1393 and 1396 together equals to duct number 982.
Lordship. Now, that being the position, your lordship, the central issue is whether the appellant vendors had the legal authority to sell land in duct number 1396, which has led to the dispute over the mutation of 1 bigha 2 kota 18 lessers in favor of the appellant. 5. The appellant claims ownership of the land. Appellant means this petitioner, your lordship, on duct number 1396 based on her purchase from the pro forma respondent. However, the respondents have submitted that the vendors of the appellant had right over land in duct number 982, not duct number 1396. The respondent assert that the land in duct number 1396 measuring 4 bigha 2 kota 4 lessers was sold to them and their names were duly mutated in the records of right of on 28/11/2011. Now your lordship will come to paragraph 9. The appeal is partially allowed. The impugn order dated 21/12/2021, that is passed by the ADC, passed by the learned additional deputy commissioner so is upheld insofar it pertains to the cancellation of the appellant's mutation in duct number 1396. The 10. The appellant's name, which was unlawfully struck off from the records of right for duct number 982, is ordered to be restored. The land measuring 1 bigha 2 kota 18 lessers purchased by the appellant under duct number 64, cell deed number 6491, that is so is her lawful property, and her mutation over this land is to be done afresh. So this is the finding, your lordship, which is actually perverse basically on, and it is beyond the record, your lordship, contrary to the provisions of the law as well as, your lordship, contrary to the records also, your lordship. So when it is the admitted position of the for the learned board, your lordship, that dispute is with regard to ownership, that means title, right and interest. Right, title and interest, it includes in one word, that is the ownership right. Right, title and interest, and plus mutation. So these are in dispute. In the objection before the ADC, your lordship, we raise the point, your lordship, that their sale deed is not correct. It is actually the persons from whom the respondent 3 and 4 purchased, your lordship, he had no title to sell 4 bigha 2 kota 4 lessers of land. We have raised such objection, your lordship. In view of such objections, the revenue code being not a civil code, it having no power to take evidence and other documents in consideration without the same being exhibited, proved and exhibited, your lordship. So they can't give any finding. That's why, your lordship, there are a number of decisions of our High Court that when such dispute arises regarding ownership, right, title and interest or mutation, that should be referred to the civil court. Civil court is the competent court because civil court will decide after taking recording evidence, considering the documents from both the sides, and they will come to frame issues, and thereafter they will come to positive finding issue-wise. Who is the owner of that land? Who is in possession? Who is not in possession? Who has no right, title, interest? All these things will be decided by the civil court. So it is the admitted position, settled position, Your Lordship. Any dispute with regard to ownership, title, right, and mutation, Your Lordship, it is not within the domain of the revenue court, Your Lordship. Revenue authorities. Revenue authorities means, Your Lordship, ASO, circle officer, SO, Your Lordship, ADC, then Board of Revenue, Your Lordship, and then Your Lordship under Article 226, it is challenged. So that being the position, Your Lordship, I refer to some decisions of the, I would like to refer some decisions of the our High Court, Your Lordship. And
the conclusion of the Board of Revenue is only on the basis that this is 13, you are 982 and not 1386.
But I have purchased showing 982 is the old duck and
In your sale deed, both are mentioned.
1396, and my name has been mutated also, Your Lordship. It is not that, Your Lordship. Mutation means, Your Lordship, that I have title as well as I have possession, because mutation is granted under section 51 and 52 of the Assam Land Revenue Regulation, Your Lordship, on the basis of title as well as possession. So both the ingredients are there, Your Lordship, so far my mutation is concerned. So that being the position, my mutation cannot be at any cost, can be cancelled by the revenue authority. And as I have cited, Your Lordship, this provision of section 151, earlier passed by the order of mutation of my vendors, Your Lordship, that is Konak Boshyo and Sondo Boshyo, Your Lordship, from whom I purchased. That mutation cannot be cancelled by ADC later on, because he has no power.
151.
151, Your Lordship, once he has passed the order, he becomes functional. He can't. Even then, Your Lordship, he dared to interfere with that order, Your Lordship, of my vendor's name has been cancelled. As a result, sequential Lordship, my name has also been cancelled, Your Lordship, from mutation. So that being the position, Your Lordship, I beg to cite decisions of our High Court, Your Lordship. Go ahead. It was 339. And it was 680. And it was 705. Lordship will come to paragraph
Which one?
15,
first
14,
judgment?
17, 18, 19, Your Lordship.
First, which judgment? First.
17, Your Lordship. That is 208, 2008, 3 GLT, 339. Honorable Justice B.K. Sharma, 2008, 3 GLT, 339. Got it, Your Lordship. Paragraph 17, Your Lordship. At the instance of the circle officer, passed the order dated H7/2003, Annexure 3 to the writ petition, allowing mutation in the name of the petitioner. The order was passed primarily upon a reference to the aforesaid title suit, and also on the basis of the possession of the petitioner over the land. The appellate authority also, while upholding the order of mutation by his order dated 27/1/2004, Annexure F to the writ petition, referred to the title suits, and so also the provisions of the Assam Land and Revenue Regulation and Section 27 of the Limitation Act. He acted as a civil court to decide the issues of right, title, and interest of the parties. The Assam Board of Revenue, by its impugned judgment and order dated 28/9/2006, Annexure G to the writ petition, has exclusively dealt with the matter, and upon setting aside the order appealed against, rightly observed that title by way of adverse possession can be conferred only by the competent civil court and not by the revenue court. Provisions has been made in the impugned order that the possession of the petitioner over the land in question will continue unless and until otherwise decided by a competent civil court. Here, your lordship will find the circle officer, your lordship, granted mutation as if, considering the facts, your lordship, as if it is a civil court. The learned board of revenue, your lordship, set it aside, holding that revenue or the circle officer has no power or the ADC has no power to do so. Liberty has been also granted to the petitioner to approach civil court for declaration of right, title and interest over the land in his favor by way of adverse possession. Adverse possession, your lordship, cannot be given either by circle officer
By revenue court.
or board, because that is a matter to be decided on the basis of
Evidence.
position and on the basis of evidence, your lordship, to that effect. Specifically, your lordship, who claims adverse possession. Now, it is not within the domain of circle officer, ADC or the board. Adverse possession, your lordship. Liberty has also been granted to the respondent to approach the civil court for declaration of right, title and interest, recovery of possession as per the provisions of the Assam Land and Revenue Regulation. Now, second petition I am citing, your lordship, that is 2023 6 TLR 705. Lordship got it.
Yes, yes.
Paragraph, your lordship, 11, 12, 13. Your lordship, 11. This court has duly perused the order dated 31/12/2012, passed by the Additional Deputy Commissioner Kamrup Metro in such and such, as well as the order dated 19/8/2013, passed by the learned Assam Board of Revenue, so and so. The findings of both the authorities, in the opinion of this court, that the dispute needs to be resolved by the civil court, taking into account that there are certain disputes as regard the genuineness of the gift deeds. Here the sale deed, your lordship, but this is the case, gift deeds seem to be reasonable conclusion arrived by both the authorities. This court further finds it relevant to take note that in the meantime, the petitioner had also filed a suit being titled suit number 56/2013 before the Court of the Civil Judge Senior Division, Kamrup Metro, which is also presently pending, wherein the gift so executed in favor of the respondent 2, 3 and 4 has been challenged, as well as the declaration of the petitioner's right over the land in question has also been sought for. Similar is the prayer in the suit actually which we have filed, your lordship. We have challenged their sale deed, challenged their mutation, your lordship, hearing for our declaration of right, title and interest, and our mutation should be kept in intact. However, this court finds it relevant to take note that though, there are 12 I am reading, your lordship, both the authorities, the Additional Deputy Commissioner and the as well as the learned Assam held that it is the civil court who has to decide. But surprisingly, the said authorities, instead of relegating the parties to the civil court, cancelled the mutation and reinstated the name of the mother of the petitioner, who has already expired on 21/12/2009. It baffles this court to observe that when the basic intention of mutation is correction of revenue, why the authorities concerned reinstated the name of the dead person? Under such circumstances, this court therefore interfered with the order dated so and so passed by the learned Assam Board of Revenue so and so, as well as the order dated so and so passed by the Additional Deputy Commissioner so and so, to the extent of reinstating the name of the mother of the petitioner who had already expired. This court further restores the name of the petitioner in the mutation records in respect of the land in question, and as such, restoration shall be subject to the outcome of the civil court. So, if my name, your lordship, is restored from being cancelled, your cancellation is the okay, then that will be subject to the result of the civil court. If the civil court decides against me, your lordship, my mutation will go, my sale deed, it may affect also, your lordship. On the other hand, your lordship, if it is found by the civil court that my sale deed is genuine, it is in respect of the land which has been sold, your lordship, by the vendor to the petitioner, and possession is there, mutation has been rightly granted, then your lordship, they will be out. So it is within the domain, within the province of the civil court, your lordship, not by the, not before the any revenue courts, your lordship, as has happened in this present case, your lordship. Now, this decision, as well as the other decision, I am placing another decision, your lordship, that is 2006 3 GLT 680. Para 9, your lordship. Para 9, your lordship. The alleged admission of the plaintiff on which heavy reliance was put by the learned trial court is in fact a perverse finding, inasmuch as the plaintiff number 1 immediately after stating that the defendant vacated the suit house in the year 1969 has further stated that in the year 1972 in the month of March, the defendants again returned back to the suit premises, and this vital aspect was left out of consideration by the learned trial court. And this statement of the plaintiff is in consonance with the statements made in the plaint, inasmuch as the claim of the plaintiff is that the suit premises were taken into rent in the month of March 1972. The other consideration of the learned trial court was that the order of the Revenue Board set aside the mutation order. The order of mutation is only to facilitate the payment of land revenue. Revenue court is not entitled to decide title in respect of any property, which is the subject matter of the civil court. So here the court, your lordship, based the finding on the basis of the revenue court, your lordship, that is the circular officer, ADC, Board of Revenue. So the Honorable High Court has held, no, you will have to come to an independent finding based on the record, based on the decision, and then give a finding, not on the basis of the finding given by the revenue authorities. Revenue authority is not the authority to decide the title when a dispute is there in between the parties in respect of ownership, right title. These are the things, your lordship, which was considered in this case. Your lordship will go through the decision. I'm just pointing out the relevant portion. Another decision, your lordship. Recent decision, let's say I don't have copy, just I'm reading, your lordship.
Can give me the citation or number or something?
2023 5 GLR NOC page 8. Just I'm reading, your lordship. Challenge to the validity of the sale deed. Here they have challenge. Power to adjudicate dispute challenging the validity of a registered sale deed is in the realm of a civil dispute and within the domain of a civil court having jurisdiction over the matter. Additional Deputy Commissioner does not have the power and jurisdiction to make any order on presumption against a registered sale deed. Now, your lordship, I am referring one paragraph from our objection. Our objection, your lordship, Annexure 11, page 73. Page 73, relevant pages 74, your lordship. This is our objection as against their petition, praying for cancellation of our mutation. Let page paragraph 6, your lordship. Got it, your lordship.
Yes, yes.
That as regards the statement made in paragraph number 1 and 2 and the amendments made in the application dated 29/12/2014, 30/12/2006, 74. It is replied that those are incorrect, false and baseless statement and hereby denied. The applicant as per the sale deed dated 14/11/2011 had purchased a plot of land measuring 4 biga 2 quota 4 lessons. Applicant means respondent number 3 and 4 here, lordship here. 4 biga 2 quota 4 lessons covered by Doc number 1396 of Capital number so and so, Moja so and so. But the vendors of the applicant did not have right to transfer said land. So this is a serious dispute we have raised, your lordship, that their vendors had no right.
Why? What was the reason?
Reason, your lordship, the person from whom they purchased, your lordship, they don't have that title, your lordship, to sell 4 biga 2 quota 4 lesser. They got title, your lordship, but for lesser area of land. But they have sold, your lordship, 4 biga 2 quota 4 lessers, of which they were not the owner. They did not have the title. So these things, your lordship, these are things, relevant things, your lordship. I have raised objection. And these are the allegations made in the plaint also, your lordship. So the civil court will go through all these allegations, averments, your lordship, statements made in the plaint as well as in their written or whatever pleadings they have made, your lordship. The court will decide. Now the revenue court has no business, your lordship, to cancel my mutation, your lordship, on the basis of baseless and illegal sale deed, your lordship, relied on by the respondent number 3 and 4. So these are the major things, your lordship, I have pointed out in my objections. These things have not been discussed at all, your lordship. Now, in a summary way, lordship, rejecting my prayer without considering my contention objection, your lordship, both the ADC as well as the Learned Board of Revenue, your lordship, passed the impugned orders as if I don't have any right title in interest in Doc number 1396, your lordship.
We have got your point.
And this being the position, your lordship, it is a fit case. So my prayer is, your lordship, so let my mutation be intact, your lordship. And observation may be made, your lordship, that whatever has been done by the revenue authorities in this regard, that shall be subject to the decisions, decree, order passed by the Learned Civil Court, your lordship, in due course, your lordship. In that case, your lordship, neither they are losing nor I am losing, your lordship. Everybody will be gainer, your lordship. And the matter will be cleansed for once for all, your lordship. That's why, your lordship, this petition should be allowed that way, your lordship. So my mutation cannot be cancelled.
We'll hear Mr. Saiwal.
Sir, I shall make it very. Tag number
You are
one.
for 3 and 4.
Huh?
Respondent number 3 and
Tag number 1396 is a not new tag, my lord. If your lordship goes to the original Jamabandi, which is at page 137, it's of my affidavit.
137.
137. My lord, the original also I have in Assamese version I have given. I've given the translation. Lordship, got it, my lord? In patta number 155, my lord, there were 4 dags. 760, 982. My lord, this is their dag. 988 and 1396. Now, if your lordship see, my lord, on the right hand side, co. Note co. As per order of the Deputy Commissioner in, my lord, so and so, 13666, and as per order dated 3666, additional Deputy Commissioner, and as per order circle officer measuring so and so, dag number so and so, dag number so and so, is deposited challan till the year so and so record is corrected and keeping the patta intact, making it a different patta 665. So this patta dag number, my lord, 982 and 988 has been made different patta. Now, LLC got it, well?
Just a moment, sir.
So this land was, my lord, sold for non-payment of revenue. That is why, my lord, when the revenue is paid, my lord, it was restored and it has been made a different patta.
Okay.
Your losses may come to page 140 next, my lord, jump. 982
Mm.
and KP pattern number 665, my lord.
Mm.
Yeah. Huh? Now, next, my lord, Jamabandi, your losses may come. This will make it clear. At page 143. Because these two DAGs were there in 665, 982 and 988. Here, my lord, if you also see, my lord, so the 982 is a different DAG, 1396 is a different DAG.
But 982 has 20 bigger, 1 kotha 15 lesser.
Yes.
And Kiran,
Yes.
Boishaw and all, their names were registered against this land.
Now your losses may come again, my lord, to 146. After, my lord, well, this DAG has become a new DAG 1093, not 1396. 982 become 1093. Here, if you'll also see, number 4 and 5, my lord. Momot Boishaw and Horakanta Boishaw. These are, my lord, predecessor of Konok Boishaw and another, from whom the petitioner. This is the land, my lord. This DAG has become 1093, new DAG, not 1396.
For 982, part thereof has also become, it's come under that patta.
Yes.
Okay. DAG number 182 and this.
Now again, another patta has been given 176, my lord.
Now the patta number has also changed.
Right, yes. So this is the land, my lord, where, my lord, the name of Momot Boishaw and Horakanta Boishaw is there.
So 20 bigha, 1 kotha.
Yes, that becomes, my lord, lesser now. It becomes 9 bigha.
No. Then 1 bigha taken out.
Yes.
And amalgamated with another bigger DAG and even one particular patta number. Now you say that in that DAG number, page 146, only 9 bigha, 3 kotha, 14 lesser land exists.
You're saying, my lord, 9 bigha, we can write for lesser. But this 982 become 1093, not 1396. 1396 is an old DAG. Now, my lord, next 149, if you'll also see. This 1093 DAG is there, my lord. The new DAG. Patta number again changed, 432. Is that, my lord? Here, my lord, what happened? The name of Boishaw has been omitted. That is why subsequently they applied for mutation, my lord. Being the legal heirs.
The land was in the name of his father.
Fathers, my lord. Two fathers.
Which is one?
Horakanta Boishaw and, my lord, that 146. 146. Momot Boishaw and Horakanta Boishaw.
Momot Boishaw and Horakanta Boishaw, they are the father of my vendor, your lordship. Since 1960, their names are
Boishaw and
Horakanta Boishaw.
Horakanta Boishaw, since 1960, your lordship.
Yes.
They are the pattadars and their sons are Konok Boishaw and Chandra Boishaw, your lordship, my vendor.
I am not disputing that, my lord.
And their land is all along your lordship is 1 bigha 2 kotha 18 lesser.
Yes. Now, if your lordship see, my lord, this 1093 has become new DAG. 982 become 1093. And it is their land, my lord. So far, my land is concerned, my lord, we have purchased the land of 1396, which is originally 4 bigha 2, my lord. If you also see the original patta, there it is there, 1396, 4 bigha 2 kotha 4 lucha at 137. Original, that is Dag. And that land has been purchased by that's one number 2 and 3, 3 and 4, 2011. And their names were mutated. Then what happened, my lord? Anak Boisho and Stondo Boisho, they filed a petition behind our back before the ADC, not circle officer, my lord. Before the ADC, without issuing any notice, my lord, my name has been cancelled so far 1 bigha and odd is concerned. And their names has been mutated in my DAG, my lord, 1396. Which is wrong, my lord. Their DAG is 1093. 982 become 1093. My name was, my lord, mutated, and my name, my lord, without giving a notice, my name has been cancelled so far 1 bigha land.
Who cancelled?
ADC. ADC was
With
not
the same order.
ADC order. That is not the authority, my lord. Actually, circle officer should have done it. That is why, my lord, this subsequent petition has been filed, correct order. Because without hearing me, that order has been passed, without issuing notice to me. Now, Board of Revenue has very much made it clear, my lord, if your lordship, my learned friend not placed the main paragraph, paragraph 8, page 116. Lordship see, it's clear from the submission that land in question belongs to 2 different DAGs, 982 and DAG number 1396. Appellant vendors were legally connected to DAG number 982, whereas defendants' ownership of land in Leicester DAG number 1396 is undisputed. The sale of land by the appellant vendors who did not possess right over the DAG number 1396 is therefore illegal and void. The respondents have provided valid sale deeds and records confirming their ownership of the entire land of DAG number 1396. The mutation granted in the appellant vendor under DAG number 1396 was incorrect, as they have no legal right over their land. Consequently, the order of mutation dated 27/5/13 in favor of appellant vendors was rightly cancelled by the Additional Deputy Commissioner Kamrup by imputing order this and so. The appellants lawfully purchased 1 bigha 2 katha 18 licha of land of DAG number 982. My lord, 982 become 1093, my lord. That has not been mentioned, my lord, in the revenue order. And sale deed number so and so. This land was correctly mutated in her name. The imputing order did not adequately address the distinction between the 2 DAGs, and appellant's rights over 982 were wrongly affected when her name was struck off from the record of right from this DAG. It is therefore necessary to rectify the records confirming the DAG number 92 to restore the appellant's legitimate ownership over the land in question. So, my lord, this is absolutely clear, my lord. The highest revenue, my lord, Board of Revenue that has corrected it, my lord, because they have purchased, because their vendors have the right in 982. 1396 is not a new DAG because it is an old DAG. New DAG is 1093. So they can be owner of DAG number 1093, my lord. 982, my Revenue Board has not said the new DAG, my lord. 1093. It become 1093. That your lordship will find at page 146.
So the conclusion of the tribunal is that
Yes.
the vendors of the petitioner, of
Yes.
the petitioner hearing,
Yes.
have a connection with 982,
982.
and you have a connection with 1396.
1396. So, my lord, this is not a, my lord, the title, my lord, virtually. The DAG, my lord, DAG number. Wrongly, my lord, it has been because mentioned here.
So where is this DAG number 982 now?
I need to become 1093, my lord. That is, your lordship will find, my lord,
Annexure
at page,
8.
at page, my
Annexure
lord. I'm,
Eight.
lord.
Annexure 8 of our petition,
My lord, page number 146, my lord.
63,
Page number
We'll
146.
come back. So,
My lord,
no.
63.
Page 60, no, 146, yes. Just complete with him, then come back to you.
my lord, I'm, yes.
Yes,
I'm
982
Page
is
146,
1093.
146, my lord, your lordship will see.
Uh-huh.
That 982 become 1093. And the next, my lord, patta is, your losses will find 149. There 982 has been deleted, 1093 maintained.
Okay.
My lord. So now, my lord, what happened? In one of the, my lord, my lord, the dispute is virtually in respect of DAG, my lord. DAG number. And this, my lord, my learned friend has also, my lord, enclosed here with, my lord. If your lordship see, my lord, at page 42, page 42 of that petition, it is 1396. It is 4 bigger, 2 kata 4 lucha. It is the original, my lord. From the original patta, it is coming, my lord. Same. Now, next, but they have a next, my lord, at page 51. I have also annexed it. Nine 1093. Their names are there, Mohammad Baisha and Horakanta Baisha.
Page
151, my lord.
982 1093.
it becomes 1093, my lord.
Mamta Baisha, Horakanta Baisha.
Horakanta Baisha, Mohammad Baisha. So, my lord, there is no dispute at all, my lord, so far there is concerned. My lord, what happened, my lord? It appears in one of the, my lord, Jamabandi, in 1396, 982 has been added somewhere. My lord, wrongly, it appears. That creates difficulty, my lord. If you'll also see, they have annexed it. I don't know whether page 63, my lord.
Okay.
My lord, that is 982 was neither here nor there, my lord. 1396 is a separate DAG. They are saying, my lord, it becomes a new DAG, not new DAG, my lord. 1396 is the original DAG. And 4 bigger 2 kata 4 licha is original from original, my lord. In 19 from 50 it is coming on. So their DAG is 1093, my lord, not 1396. They should get land from 1093. 982 become 1093. So that, my lord, revenue board has not mentioned only. 982 has been mentioned, 1093, that new DAG has not been mentioned. Except that, my lord, there is no difficulty at all, my lord. So
Yes,
that
sir.
land is, my lord, so
Your
our land,
Lordship, my
our
learned
mutation
friend
is-
has repeatedly argued that 1396 is the original DAG. Now your lordship come to page 63, annexure 8. That is not a correct summation, your lordship.
Therein 1396 and
63,
982 are shown
63,
together.
63 page, your lordship, annexure 8, 982 all, your lordship. Next page, your lordship will come in a summis.
Hmm.
Of
Tag number-
1396, your lordship, 1396. That means 1396 is new. 982 is the old. Where from my learned friend says that 1396 is the original DAG? But 1396 is not original DAG. So it is actually carved out from the number original 982. Now your lordship will come, annexure 8. Annexure 8, your lordship will come.
Now you come to page 52.
Is
982,
982
1093.
93. So that means your lordship 982 has been carved out, it will split up into 1093 and 1396. So 982, if your original, your lordship, one document says
So
one.
normally they write this, what we understand in Jamamundi, two numbers are given, one is old, one is new.
Correct.
So from where does 1093?
982.
Or it should have been in that next one at page 63, it should have been 1093/1386. If-
Anyway, your lordship.
No, I'm
it-
just for my clarification.
Anyway, your lordship, 982 is the old act. The next one is the 1093, that is the act. And
Can
90,
there be, miss, that's what I'm asking you.
1396, that means
982/1093, fine, I understand.
two ducks were carved out, that means.
No. How can it will be different?
Now, question is here, sir, this is the petition under Article 226.
Hmm.
Now, under Article 226, your lordship will decide whether the courts
Orders
will-
have been passed with jurisdiction, that much only.
because new finding cannot be given by the
No.
honorable court,
No.
because that would be again, your lordship.
The maximum we can do is whether the materials on record support the orders of the ADC and the deputy and the Board of Revenue. If the Board of Revenue and the thing have come up, then the only way out for you would be to take the civil proceedings to its logical conclusion. And only we have to examine whether pendency of that, during the pendency of that proceedings, whether the materials are sufficient enough to direct the authorities to restore your mutation. These are the two issues this court has to decide. Anything further to be decided?
Now, your lordship, if new finding is given, then it will affect the result of the title suit.
I told you, I'm not giving a new
That's
finding.
why,
I'm only examining whether your prayer for restoration of the mutation and for interference with the orders of the ADC and the ABR is a proper materials are there. If it is there, we will interfere. Leave the parties to its own cost. If we are not satisfied, if this court is not satisfied that the materials do not support, then we will have to reject your writ petition, albeit by giving reasons, but with a protection that all these findings would be subject to the outcome of the civil.
correct,
That much only.
Yeah. subject to the result of this.
No, two stalwarts were here. So I took this opportunity to get myself also acquainted with these matters. It's a learning experience.
Now, actually, the consideration, so far the ADC and the Board of Revenue is concerned, it is partial. They have not considered the entire facts,
No.
figures, your lordship. That's
And
why,
I will
your
also
lordship,
have to keep in mind 151.
now, so for the 151, your lordship, he has revised the earlier order passed
That-
by the ADC.
That cannot be.
So he has no jurisdiction else. He can't exercise that jurisdiction, your lordship, to reverse and review the earlier order passed by his predecessor. That 151, your lordship, is a bar. He
Okay.
can't.
Heard Mr. S. Ali, learned counsel, appearing for the petitioner, and Mr. J. N. Saiwala, learned senior counsel, appearing for the respondent number
3 and 4.
3 and 4. I'll just list it. I'll just go through one. If there is any clarification required, I'll take it. Otherwise, I'll pass the order. Hearing remains inconclusive. Registry to list this matter again on. Fullo parina. Toro. No, no. Hearing it ever delivery of order going. Toro. On 18/9/2025.
Hello, the 18, I shall not be.
When it's
18 and
17?
19, I shall not be here.
17? Okay. 17. At 2 p.m. At 2 p.m. At 2 p.m. Madam, just write down the names and give it to her. Your name also assisted by so and so. Just give it to Mr. Hendricks also you take. Okay. Reflecting the name of the standing council, revenue in the cause list. Huh? Hearing. For further hearing. Admission or delay? For yeah, further hearing. Yes, what is your instruction? The stop notice is because there were some OMs and all. 100 meters something aerial distance, you cannot make a construction. Yes, what is this?
I am for the respondent number 1, 2, and
Ah,
3, my lord.
ah.
Circle officer will respond.
In this case, we have got.
Huh?
Extra copy will be served.
Mr. N. Goswami, Learned Counsel for Learned Government Advocate, appearing for the state respondent submits that the instructions could not be received as the petitioner counsel had not furnished to him requisite extra copies of the writ petition. Mr. Bora submits that the copies of the writ petition has been handed over to the Learned Counsel for the petitioner in the court itself today. So, in view of the above, registry to list this matter after 4 weeks. In the meanwhile, the Learned Counsel for the respondents shall complete their instructions. Prayer is made on behalf of Mr. R. Sharma, Learned. Yes, what is your instructions? You are for?
Respondent number 5 and 6, municipality.
Huh? Municipal board. You are for? You have filed your pleadings? Complete. Yes, madam. What do you want? I'm not sure. We may not be here for the whole length today. Who is your senior?
R. Sharma.
You are ready for the hearing? All of you should say it.
My lord, the case, my lord, here I have pleaded in paragraph number 8, my lord. What happened, my lord? 1st of December 2024, my lord, the police from police station, my lord, arrived, my lord, at my premise of the land, my lord, locked the gate, my lord, and took the key. And then, my lord, asked, my lord, why, my lord, the gate has been locked, my lord. Then I was, my lord, and brought to police station. Thereafter, I produced all the documents of the
They have
land, my
filed
lord.
an affidavit now.
They have filed affidavit, my lord, on the strength of a complaint, my lord.
Lock that door. Lord.
Have, my lord, here filed an additional affidavit, my lord. Here, my lord, 8. The big, my lord. Anyway, my lord, documents now have been given during the pendency. Documents have been given.
What is the documents that the land belongs to you?
Yes, page 25, my lord, kindly see, annexure 3. Was the, my lord, LOC for transfer of land in my favor, my lord. Momirul Islam, my lord.
And what is the documents for
My lord,
the other man?
other man's document, my lord, he has not submitted along with his, my lord. That affidavit is filed only on complaint, vague complaint, my lord. No document is found, my lord. Kindly see page 56.
He is not a party here. You must
Name-
make him a party
No,
also.
his name even was not known, my lord.
Oh, fine, that time you did not know, but now that we pass some orders, This process is, if he has any grievance, ask him to go to the civil court.
Civil court, that is
That
the
is not mentioned in our affidavit, Lordship.
Where?
And matter that has to be.
Can the police put him back into possession? Then? What are you? Why are you going into this unnecessary things? You have better work to do. Huh. If it is a case of land grabbing, register a case. You have not registered a case till now. What is the case registered after this complaint? Why are you doing all this without non-FIR case also not registered? Nothing registered. Why? How are you acting in this manner?
Complaint.
I know you received a complaint. You have taken steps without registering a case.
Disputed there.
Okay. What did you do after that? You are not being allowed to go into your house till now.
No, we have not done anything.
Where have you said that you have not locked it? Land is still under lock and key, under possession of.
Under my possession, my lord, because I have constructed wall, then I
Okay,
have
but it is kept locked.
kept lock. The picture, my lord, kindly see of my additional evidence, page 48, my lord.
Where is your statement to that effect?
Paragraph 8, my lord. Of my writ petition.
A GD entry was made. Now the police will determine whose land it is.
We have subsequently requested the complainant not to take any, undertake any further activities, Lordship.
Who are you? How can you determine that? For that, let him go before the
Yes.
civil court. Why are you entertaining all these things?
As we have made some inquiry, subsequently we have.
No, you have you have not denied that you have not kept the thing in lock and key. Open it. Heard Mr. M. Mullah, learned counsel for the petition. Also heard Mr. N. Goswami, learned counsel for the respondents. Mr. Goswami submits that he would receive further instructions from the respondent authorities with regard to the, from the respondent number 6. That is the officer in charge, Dispur Police Station, with regard to the specific contention raised by the petitioner in paragraph 8 of the petition to the effect that the police of Dispur Police Station had kept his gate under lock and key.
May I submit one thing, Lordship? That the officer in charge written to the Deputy Commissioner of Police, the matter of locking up gate of the gate and keep the key of the gate does not arise, Lordship. We have denied things, Lordship.
Where in your affidavit where it is?
We have not mentioned, but
I want it in the affidavit.
one letter, Lordship.
Fine, your letters, you can keep it to yourself. You have not made it part. You show me from the affidavit that this is there. This is a categorical statement. I want an additional affidavit from him. Also, the officer in charge, that is the respondent number 6, shall file an additional affidavit on the set point before the next date of listing. Also, it is to be noted that the learned counsel for the petitioner has made a categorical statement during the hearing today that the said gate of the plot of land in dispute is still kept under lock and key by the police of the Dispur Police Station. I'm only asking a clarification.
We have not locked them.
Fine, you make it, we will ask him. It issue? Daily. Registry to list this matter after vacations? No. Today is our tarik, no?
So long, my lord.
Because last week I cannot, because that is a week which will be, okay, we'll have it on 24th. 24/9. 24/9. Before any other bench without me. Pandit Pathak, what have I heard?
I am AFNU Mullah.
Last one, last week.
I am AFNU Mullah.
AFNU Mullah. I think I have written R Mullah, no, AFNU.
Yes, ma'am.
That is a problem when you are popularly known by some name. What is this?
Wait, please, sir, let's check. Item number 32 and 33, we have filed the reply, my lord. On record entry, my 34 and 35.
The learned counsel for you are also wanting to file some pleadings?
Lordship, already we have filed our affidavit.
The learned counsel for the petitioner submits that. Case submits that the affidavit that the rejoinders have been filed in WPC number
8 and 344.
678/2025 and 344/2025, and he would be filing the rejoinder on behalf of the petitioner in WPC number 443/2025 within 443/2025 and 683/2025, right? Within a period of 2 weeks from today. 3 weeks from today. Registry to list this matter after 4 weeks for admission. So interim is there. On registry to list this matter again on 15/10/2025. Interim order passed earlier to continue till the next date of listing.
Obliged, strictly obliged.
I am appearing this matter on behalf of Mr. Affidavit. Sorry, we need some time.
Affidavit was in June. A prayer is made on behalf of Mr. S.K. Singh, Learned Senior Counsel, for an adjournment in the matter. Adjournment in the matter to facilitate the petitioner to bring on record his rejoinder to the affidavit filed by the respondents. Respondent number 4. Prayer accepted. Registry to list this matters again after 3 weeks on a date to be fixed by Mr. S. Day, learned. Baki Miss N. Bordoloi, learned Standing Counsel, Revenue, Mr. N. Goswami, learned Government Advocate, and Mr. S. Day, learned Counsel, are present for their respective respondents.
So the land has been acquisition, but compensation has not been paid. On the ground that co-partner is not found. So I am praying for only 50%, my part, my lord. That effect, they have filed their affidavit, my lord. They have filed 2 affidavit, in fact. Find the notice at page 39 annexure 6. That was acquisition of the 8/3/2023.
Where is the other one?
Other one, my lord, present Patadar is also died, my lord. Daughters are before your lordship, my lord. And other Patadar, my lord, is not known. And
How long?
my lord, they are not aware, my lord, where about his.
How long he is not known?
Several years, my lord.
107 Evidence Act, go and file an application, get a declaration. Do it. Because one thing, there can be 50%, but we don't know the share. What share you have? We don't know the share. Mr. Kolita's share in that property, we don't know.
My lord, Deputy Commissioner's office, they ought to have, my lord, do something. They ought to, they should have, my lord, issue lookout notice, my lord. They
Lookout notice is for what? He is not a criminal.
No, my lord.
If he is not known, his whereabouts are not known for 7 years.
Condition is that, my lord.
A declaration can be received by his heirs.
Yes, my lord, his heirs, my lord. But his heirs are also not known to us, my lord, because we are residing at Nagaon. Land is at Golaghat. Lordship, my lord, that payment of compensation. Payment of, my lord, compensation is the sine qua non for acquisition, my lord. Without payment of compensation, land cannot.
This is under the 2013 Act.
Yes, 13. Agreed amount, my lord. In the affidavit, my lord, they have the same persons filed the affidavit. In the first affidavit filed in the on, my lord, 13/6/25, it was stated that the honorable court directs, my lord, then the payment 50% will be paid.
For that, they need not write. Otherwise, also they are bound.
Yes.
Let me think over this. Day after tomorrow at 2 p.m. At the parties at length, registry to list this matter again on Wednesday for further hearing at 2 p.m. So the legal heirs are also not there.
Known to
Maybe
us.
or may not be allowed. We also no.
But Mr. Handick, on the next date of listing, Mr. Handick, Thursday Koridia, Thursday Koridia, Mr. Handick shall receive instructions from the Deputy Commissioner, Nagaon, as to
No, my lord.
Golaghat,
Code district
commission.
whoever it is,
Code district.
Code district. Kahat, as to the land has already been taken
Yes,
over.
my lord, 23.
Already been taken over.
So people who were there, they might have been displaced now. So nothing is there.
Lordship, in our instruction in annexure to my lord, that last instruction.
No,
what
not
we have-
there.
have
I like
already
it
been
at
stated.
somewhere. Just because once that land is taken, those people will not be there. Where they have gone, God only knows. How will he find out? So ito na lage. Thursday go diya khali. 2 p.m. Thursday, 2 p.m. 8:11. No, 8 Thursday go diya. 4/9.
38, Lordship.
Hmm.
Kindly see the Lordship, the last order, 14/8/2025, Lordship.
Yes. Okay. To what do you, we have said that in the event the stand of respondents is not brought on record by way of filing an affidavit with regard to the challenge made therein of the order dated so and so disposing of the revision petition, would proceed to consider the prayer for passing interim direction. So we'll have to consider that.
Lordship comes to the page number 59. Lordship, this is the interim order. I mean, this is the order passed in the revision, Lordship.
Okay, that's sealing land.
They are saying that in spite of position of that sealing act, Lordship, they're still in occupation of the land. That is around 25 bighas.
Yes, what is your instruction on that?
The instruction, it is only that much, Lordship. It is said that they were asked for additional documents. They have nothing else, but they are.
So what happened to the sealing land, which was held to be in excess held by them?
They are claiming, but it was rejected by the authority at page number 59, Lord.
Okay, come to that.
The earlier round, Lordship, court directed to dispose of the revision, and it was disposed of, in fact.
This order is neither here nor there.
According to them, Lordship. Point number 3, Lordship.
And you are the legal heir of
This point number 3.
Nitai.
Nitai Chandradas. They are saying that out of 93, 25 bighas were mutated in the name of Nitai Chandradas. The legal heirs of Nitai Chandradas, land should be mutated in.
So, okay, where is that you had taken over this land? How you have calculated? Where is that material here? What is your instructions on that?
Annexure 2, Lordship.
Page?
29. Earlier order, Lordship.
Read.
Kindly allow me to read the SMS.
That's what I'm with that only.
1976 চনৰ অসম ভূমি সৰ্বোচ্চ পৰিমাণ সংশোধনী 73 ধাৰা মতে আপুনি আৰু আপোনাৰ এটা পৰিয়াল, here the word use is family. Now they are saying that out of 93, 25 in the mute. The here word is his family. So it was the land.
Read.
পৰিয়ালৰ ভিতৰত থকা 54 বিঘাতকৈ অতিৰিক্ত 37 মাটি আজি 21/5/76 তাৰিখত অতিৰিক্ত ভূমি চূড়ান্তভাৱে
Really. অতিৰিক্ত
বুলি চূড়ান্তভাৱে ঘোষণা কৰা হ'ল আৰু অধ্যাদেশৰ 7-5 ধাৰা মতে প্ৰকাশ কৰা হ'ল। লগত গাঁঠি দিয়া প্ৰতিবেদনত আৰু 14 কলমত মতে উক্ত অতিৰিক্ত মাটিৰ দখল উপপতি সমাহৰ্তা ভূমি কেন্দ্ৰ
আইনৰ
প্ৰতিনিধি দখল সমজাই দিবলৈ। That was the order, Lordship. Against this order, Lordship, a revision was filed. That was decided in the year in court's order. It was this
Sudhir Das is Nitai Das' son.
order. Sukal Das was the
No. Sudhir Das.
Is the
Sudhir Das.
father?
Sudhir Chandra Das.
Sudhir, Nitai and Gaur, they are the three brothers.
So where is you are whose hair? You are hair of Nitai.
And Gaur Chandra.
How?
Worship this
Who is your father? Nitai or Gaur?
both Lordship.
Both are your fathers.
No, Lordship, there are some other legal hair of Gaur Chandra and Nitai Chandra.
Who is the petitioner here?
All are
three
petitioners.
petitioners. 4 others. 3 and petitioner.
So
and 3
Sefali is the
Yes.
Gaur Chandra. Gaur Chandra. Nitai. Or 2 from Nitai, 2 from Gaur Chandra.
Gaur Chandra, yes.
Okay. So where is this document to show that the land was taken over from them?
order was passed, Lordship.
Where? That is that they will have to hand over the land to the appropriate authority. Where was the order? Because subsequently they say that the land is still in their possession.
They are saying, Lordship, it was
That is why we asked you to get that instruction, Mr. It's in your area. It's in BTC area.
so far as my understanding is no.
Your
it was of
understanding,
96.
we'll have it.
No, it was
But what is the basis of your understanding?
once this order is passed, Lordship.
That is it. But how do you collaborate that with the subsequent statements that the land is with us? You come up and say that the land is not with them. Land is still with you?
Yes, Lordship, they are documents saying. Page 52.
You come to 34.
There are many documents, Lordship, they are, after verification, they are saying that this land is still under the possession.
They are, it's not reflected in the land records. What is your problem if the land is with you?
My lord, after the death of my Lordship father.
Mutation is
the authority to.
They are not giving you the
Yes.
mutation. Yes, that is exactly what we wanted.
Instruction received, Lordship, how the revision was disposed of on.
We are not concerned, we know that.
Here basically, Lordship, this decision was silent, saying that no reasons has been.
I know that,
disclosed.
Mr. Nayak, we know that. But the fact remains that you said that it's selling surplus land, so we have taken it over. They say, no, you have not taken it over. Land is still with me, but whenever I approach you, you take the plea that this is land, selling surplus land, so we will not mutate the, by inheritance, you are not going to get it. Suklal's land is selling surplus. But during his lifetime, it went into Gaur and Nitai.
Lordship comes to then page 30.
34,
First
yes.
line, Lordship, but the said line is being Gorsandra Das.
Gorsandra Das, yes.
Yes.
Gorsandra Das is their predecessor of 1 and 2, petition number 1 and 2.
Here only facts that comes out, Lordship. It was not allotted to anybody else.
Fine, because it is
Argued
there in, that means that 25 bighas of land remained in the family. There was only a notice or something, but it was never taken over. Normally, sitting surplus land is often taken, either kept as government land, or it is, yes, in land records, what it is reflected as still government khas land or
No. Lordship,
in
this was-
Suklal Das.
See, Lordship, this is under, this was recorded in the name of
Suklal Das.
Gorsandra and Nitai Chandra.
Nitai Chandra. Still continued.
Still.
Yes, Mr. We'll have it day after you have your instructions. As prayed for by Mr. P. Nayak, learned. You are standing counsel BTC.
Yes, Lordship.
Standing counsel BTC. Mr. P. Nayak, learned, standing counsel BTC, submits that he has received the instruction. However, he has not been furnished with the information as to the status, nature of the status of the land in dispute in the present proceedings. So he submits that in the event the said land has been declared to be ceiling surplus land, he has not been furnished with the instruction as to whether the same was thereafter reclassified as government land. Mr. Khan, learned counsel for the petitioner, submits that the land continues to remain as a patta land and in the name of the fathers of the petitioners. Right?
Right.
So, Mr. Nayak shall complete his instructions and apprise this court about the same on the next date of listing. Registry to list this matter again on 10/9/2020. No further adjournment would be granted.
Can it be as part of this?
Yes. Who are you?
Lordship, I'm appearing on.
Who is he? Life insurance. Why the instruction that last time we had all boiled down to something? Oh, why? It was done on 7/8. We are in 1/9. Why the instruction is not here? Where is Mr. Kundu?
Out of station, Lordship.
Tell that. When is he coming back? Tomorrow? A prayer is made up. We'll have it on Monday. Any
Friday?
Friday would be
Hello, as your lordship pleases.
Friday. First तारीख. Problem nahi na? A prayer is made on behalf of Mr. A. Kundu, learned counsel appearing for the Life Insurance Corporation respondents for an adjournment in the matter on the ground that he is out of station. For prayer is not objected to by the learned counsel for the petitioner as well as the other learned counsels representing the other respondents. For accordingly, registry to list this matter again on 5/9/2025. We'll see. Tell Mr. Kundu to have something positive, otherwise we'll be very serious in this matter.
Did a prayer in the morning.
Why did you come? I just wanted to.
I thought since
We have already made a note. Mr. Sharma, he could not contact you, so we did not pass the order. So, Mr. S. Dr. Learned Senior Counsel appearing for the. You are for the.
Number 6.
Appearing for the respondent number 6 summits that, who is assisting you, Mr. Doctor here? The learned, Miss S. Paul, learned counsel, assisting Mr. S. Dr. learned counsel, representing the respondent number 6, praised that the affidavit in the matter is ready and would be filed within a period of 2 weeks from today. So, prayer is not objected to by the learned counsel for the petitioner. So, accordingly, a registry to list this matter immediately on conclusion of 2 weeks from today.
That may be fixed.
You get it in the last week. I'm not fixing it. Make a mention. We'll take it up. Don't worry. And if I forget, tell you that I told you. Okay, that information. Oh, yes.
Information.
Lekha, list this matter again on 17/9/2020. That one has given, one has not given. Mr. Doctor has not given. So we wanted him, why he is not given.
Is to non-payment bill of the petition of the contractor, my lord.
Yes.
What's your awaiting instruction in this matter, Lord?
Why? Very difficult to reconcile. 8 lakhs odd.
Penal, my lord.
Only 8 lakhs?
8 lakhs 95,000.
95. Yes. Peanuts for you. Mighty PHC. And maybe big thing for the petition. So when are you filing the affidavit?
So we take
Don't ask for 2 weeks. That much only we want. There is not admitted, tell us, we will dismiss the petition, ask them to go. Admitted, we will direct them to pay. When?
After a week.
Mr. R.R. Gogoi, Learned Standing Counsel, PHC, submits that the affidavit on behalf of the respondents represented by him would be filed on or before 11/9/2025. Registry to list this matter again on 18/9/2025.
Online.
39.
Please, Your Lordship. Instructions to withdraw this matter.
Your colleague had made a mention
Yes,
in
my
the
lord.
morning. Mr. J. Singh, Learned Counsel for the petitioner, submits on instructions praise that the petitioner desires not to press the matter any further, and accordingly he prays that he be permitted to withdraw the present writ petition. I got to submit over there. Mr. J. Singh submits on instruction that the petitioner desires not to press the matter any further, comma, and press the matter, full stop. Accordingly, he prays that he be permitted to withdraw the present writ petition. So, prayer is not objected to by Mr. R.R. Gogoi, Learned Counsel, appearing for the
Excise Department, Lordship.
Learned Standing Counsel, Excise Department, appearing for the respondent number 1, 2, 6, and Mr. J. Handick, Learned Counsel, Government Advocate, representing the respondent number 7. Full stop. In view of the above submissions of the Learned Counsel for the petitioner, the present writ petition stands dismissed on withdrawal. Yes.
Lordship, in terms of your lordship.
When can you pay the money?
Yes, that order, lordship, I communicated on 18/8. I received one letter, lordship, it's not in order, lordship, it is
Tomorrow morning at 10:30.
tomorrow, lordship. I'm playing 3 days time, lordship.
Mister, you're already in
Yes,
contact.
lordship. I have already.
Now we had given you an opportunity. Now, if you don't want to take it, we can't help it.
I'm 3 days, lordship. They sent something, lordship, but it is found it not in order, lordship.
Mr. P. Naik, Learned Counsel, representing the respondent, submits that he be given time till 8/9/2025 to receive instructions with regard to the query QUERY raised by this court wide order dated 13/8/2025. Registered to list this matter again on 8/9/2025.
Two 43 and has been admitted by the petitioners that due to paucity of funds.
What about 43 and 44?
42 and 44. 43, my lord, has been admitted by way of-
43 admitted.
43 has been admitted, my lord, 4552.
4552, your lordship.
They filed an affidavit, my lord, not disputing the claim and saying that
There's a verification. Right.
4552.
4552.
Good, eh? 4552. And a file to put.
4552, item number is 43.
Have they filed an affidavit earlier to this?
I filed affidavit by the executive engineer. There also verification.
Now, where is the affidavit by the executive engineer?
starts at page 27, my lord.
Not here.
If I may provide a copy, my lord.
When was it filed?
It was received for the in July 2025, my lord.
And what about the other two? See, that there is admission there.
In 4.
Completion certificate, your lordship.
What is the chief engineer's?
Yes, remarks, your lordship. Presently, the DG set is for non-functional. Such completion certificate cannot be submitted as required for placing the fund demand. The bill.
When was this work order dated? 14.
Work order is 14.
Those matters, DG sets.
It's different. They will different DG set matter.
This is earlier, that is earlier. File an affidavit.
Bring on record the report.
Yes. And when today, after, was the DG set required to be maintained by him continuously? For how many years?
They have not given a timeline. Your lordship.
Because this seems to be of 25. Okay, after 11 years, it might be not working.
But even in that point of time, he didn't submit it.
That is for you to say.
Yes, as per remarks of the expert.
Chief engineer doesn't say anything. He said we cannot do it. But why was the completion certificate? What is the material? You have not, even the divisional authorities are not saying anything.
Page 20, your lordship. And
Of the contempt petition, writ petition. Page?
down below consignee payment, your lord. Payments will be made after that and as per performance of the work will be paid after successful period of 3 months. It's important to inform you that payment will be available on installation.
Now show me that within 3 months, this was not functioning. Where is your material? What material do you have for that?
Submit after 3 months of completion certificate. You have to submit before
How
the
can he submit the completion certificate? Completion certificate is to be issued by you.
Plus, you have to give us the bill.
When did you submit your bill, Mr. Sharma?
So that information is not.
You bring on record this, otherwise this affidavit of yours is neither here nor there. You get this fresh affidavit. Mr. R.R. Gogoi, Learned Counsel, appearing for day 3 respondent submits that although in WPC number 4552 2024, an affidavit from the district authorities has been filed. However, on further verification, the amount claimed by the petitioner is being disputed, and accordingly, he submits that an affidavit would be filed in the matter by the chief engineer, PHE, within a period of 3 weeks from today. Full stop. Full stop. In view of the above submission, let the affidavit on behalf of the chief engineer, PHE, be brought on record before the next date of listing. Mr. M. Sharma, learned counsel for the petitioner, is present. For the petitioner, sir, so accordingly, registry to list those matters again after immediately on completion of 3 weeks from today.
Item number
I'll
4,
have the required information, my lord.
When you do, you get it.
Your Lordship.
42.
In 44,
Hmm.
4557, his claim is of 16,07,000. We have admitted this claim of 7 lakh.
File that by an affidavit.
I'm grateful, man.
On release of compensation amount, my lord, only on 28, my lord, I have submitted a representation before the authority concerned that regarding, my lord, deed of agreement. No point of time, my lord, there was any deed of getting NOC, my lord, I have submitted and all the relevant documents.
So what have they done now?
On 28/8/2025, my lord, I have submitted a representation.
No.
They are only asking to submit the deed of agreement along with NOC, my lord. But at no point
This
of
could
time
be
there
the
was any deed of.
3 days of production of these 2 documents, my lord. Otherwise, money is laying with the account, my lord. We are suffering.
Have you produced that documents before?
No, 3 notices
At
were
no
there, my
point
lord.
of time, my lord, there was any deed of agreement was made.
But
If
they
that
did not
document
respond
is
to our
not
notices,
okay,
my
how we
lord.
can produce?
3 notices were there. No response is filed, my lord. As yet, I have informed from the office 5 minutes ago also, my lord.
What?
Regarding submission of any 2 documents, my lord, whether in the meantime they have submitted or not, my lord. That information I have gathered.
Come to the order. I can't go beyond this. You're not keeping well. We'll have it on some other day.
Let order be passed, my lord. I am here.
There is no deed of agreement executed. How will he produce that?
Without that agreement or NOC.
If you have not, who has to execute that?
Petition copy I don't have, my lord. I have only the quantum petition, my
Who will have to execute that? It would have been executed by the electricity company and the petitioner. This deed of agreement, who will have to execute?
Can telegraph act under
Jamabandi
Deed
copy you
authority.
can give.
Everything, my lord.
Only the deed of agreement. And NOC from whom?
From both the co-partners.
That you can give.
Yes.
Now, deed of agreement what? What is this deed of agreement?
in between, my lord, by the direct by the district commissioner, my lord. It is the
No, deed of agreement that you have written. What is that? Who executed between whom and who and who?
which is returned, my lord. Which is returned, my lord.
No. You have written in page 22, 21. Submit your bank details, 21 of your affidavit. Bank details, Aadhaar, PAN, voter card, Jama Bandi copy, deed of agreement. What is this deed of agreement? And NOC. Okay, we'll use that word also. And NOC. What is that?
NOC, my lord. If,
Hmm?
give me some time, I will inquire within the 5 minutes, my lord.
You filed an affidavit.
My lord.
What is the document? Let's see. What is your statement? So deed of NOC is co-pattata, that he will give. But deed of agreement, what is this deed of agreement?
I'm inquiring with my, or any specific date of agreement, my.
So the rest you can give it.
Yes.
Only this one is.
Deed of agreement. Deed of agreement should be made between the parties and my lord railway authorities.
But no deed of agreement was made.
In this regard, my lord, on 28/8, I have made a representation.
Give her the copy. Miss M.
I
Burma,
have received the
learned
same.
learned counsel representing the respondents, submits that she be given 2 days time to receive instructions as to the deed of agreement, as to the nature of the deed of agreement, which has now been sought for from the petitioner. So, in the event the such deed of agreement is one that is executed between the owner of the land and the railway authorities, Ms. Burman shall, on the next date of listing, also receive instruction as to whether the other land owners whose land have been affected in the matter had produced such deed of agreement to apostrophe Lihiba. Registered to list this matter again on 8/9/2025. By the time, get your cough also out of the way.
Please, your lordship, I have already passed the SIP.
Oh, that we have dismissed it, I suppose. Same judgment. Same judgment, madam. Similar, I mean. Disposal. Madam on naam to look over. Mr. Ahmed, it will not be possible today because we have a
Sometime,
meeting.
lordship.
Because there is a National Judicial Law College, National Law College, there is a foundation day today, so we'll have to be there. We'll have it on a Tuesday. As agreed to by the Learned Council for the parties, registered to list this matter again on 16/9/2025. Mr. You have got the instructions, whatever you are ready with the matter? We had required Mr. Gogoi. Okay. He is joined back. Mr. D. Gogoi.
Gogoi, my lord, he is.
Joined back.
My lord.
Because we had required Mr. D. Gogoi, Standing Counsel Forest. Okay, fine. Just inform Mr. R. Gogoi also. R. Gogoi. Mr. Todi, you were not there on the last occasion. Yes, Mr. Chaudhary. Where is your written arguments?
Lordship, they have given a.
You have filed a written argument? On the last occasion, we had required. Your junior did not inform you.
They have Paravas comment. It will I have agreed to the petitioner.
Point of view. You give him a copy also. Mr. B. Chaudhary, learned counsel, submits that he has received instructions in the matter and would rely upon the same for the purpose of his submissions. Also, before further proceeding with the matter, this court requires that a copy of the said instructions be also furnished to Mr. A. Todi. Registry to list those matters again. Give me a copy also. On that are date time now, I guess. 11/9/2025 for further hearing. We'll finish it up with that. Yes.
12, 1912.
It is, eh?
Yes.
Yes. You are the bank. I want the bank. Where is the bank? Why the money is not being released? Yes, madam. Huh? Huh? Till now. Okay. Why the money is not being returned? Why you were given time? You were given time in 35. As prayed for by the learned counsel for the parties, registry to list this matter again on 15/9/2025. When do you want it?
Prior to 15 or maybe on
22nd? When will you be here after 15?
18.
Okay, 18th. 18/9.
Oh, bless my lord.
And madam, you or your arguing counsel should have that instructions. Why this money is being kept? Otherwise, we'll impose very heavy cost. In addition to interest.
17.
Not communicate with my client. Let
Mr. U. Dr. Learned counsel for the petitioner submits that he could not complete his instructions in the matter and prays that the matter be taken up on 10/9/2025. Also, accordingly, registry to list this matter again on 10/9/2025 for further hearing.
22.
Yeah, the circular, please join. Earlier, circular.
Mr. J. Handick, learned counsel for the petitioner,
Ask me for the
submits
time.
that he be granted time till 18/9/2025 no, 17/9/2025 to place on record as to the reasons why the name of the petitioners were deleted from the list of beneficiaries prepared by the Gram Sabha. Gram Sabha or Gram Sabha? By the Gram Sabha. Registry to list this matter again on Kiman Gusilo 17/9/2025. Let us get that, then we'll see. We're good?
30.
Yes, Mr. Soma.
On 16, my lord.
It is said pleadings complete. Stated in the bar that the pleadings in the matter has been completed. Accordingly, registry to it cannot be before vacations now.
Immediate, my lord.
Today. We were ready. You were not here. I asked them
My lord,
also.
sorry, my lord, but I am another court, my lord. I have one matter. Can he
Register to list this matter again on
18, my lord, if possible?
23/9/2025. But it will be a motion week. Let's see how far we can give you time. 23-9. Due to paucity of time, the orders could not be 1 and 2. Huh? Registry to
23-9.
list this matter at all of Didiba. Bondor age. Date to Didiba. File this one.
Lordship, can it be on other day?
Aji ek tarikh na? On 9/9/2025. This night. You want an early hearing? We are having it an early. 9/9. Any problem? Check up. No issue. 9/9. Why not Keta Asamar? As the last item. Keta Asa 70. Down 35, 75. Last item. Hey. 20, you are having problem on 23rd.
9-9, it's okay,
No,
madam.
9/9 will not, 75 items. We are not going to do it. As the last item.
Last item.
4:30.
I am here, madam.
Last 9/9 lagai thoi diya.
9-9, my lord. My lord.
এইটো দিয়া পিছত দিয়া তাতে নাই ইয়াত নহয় ছেপ্টেম্বৰতে দিয়া লাষ্টৰ ফালে দিয়া 23rd পিছত নিদিবা 25 পিছত নিদিবা তাৰ আগত দিয়া 19 দি দিয়া ফ্ৰাইডে দুটাই ফ্ৰাইডে দি দিয়া একেটো ফাইলটো মোক দি দিবা and yes
I apologize.
let him come over on what do you call that online from wherever he is. If he was not here, he should have submitted an application yesterday. Yes, did not have the courtesy to do that also. Just a slip that I'm not here, it's on the matter. When did I give it? 5th. He is coming back on 6th. 8 tarikh, 8. And immediately inform Ms. P. Chakraborty.